Good morning. We are now on the record. Call to order the meeting of the Cannabis Compliance Board for June 28th, 2022, which was scheduled for 9 o'clock. First order of business is our roll call. Call to order.
Great. Member Merritt.
Present.
Member Durrett.
Present.
Dr. Young.
Present.
Member Nylander.
Here.
And Chair Douglas.
Here. That moves us to our next item, our public comment, and we have a couple of things that need to be stated today.
Sure. Just before public comment, I would like to note that for agenda item number 9, which is the regulations surrounding consumption lounges, we'll have 2 opportunities for members of the public to provide comments. So if you do have public comment relating to the consumption lounge regulations, we ask that you hold those comments until agenda item number 9 comes up. So with that, I think we can go to Las Vegas here if anybody is here to provide public comment. Please state your name for the record.
Hello, I'm Will Adler, and I am here representing the Sierra Cannabis Coalition. Chair Douglas and members of the Cannabis Control Board. My name is Will Adler, and I am, as I said, the director of the Sierra Cannabis Coalition. But I encourage you guys to go forth and do the lounge regulations we stated we do today. That's not what I'm here to talk about, though. I'm here to talk about the greater economic concerns of the state. One of those is the lack of licensing and production in the state, because that lack of licensing is a lack of investment in new opportunities in the state as well. A lot of the people in this room here would like to see that go forward, as I said, with the lounges, but I am here to talk about those larger economic pain points, and those sort of fall into 3 categories here. But the first and the largest one is probably the currently assessed fair market value for the wholesale taxes we pay. Today, going out the door, it's about $375 a pound for the taxes alone when you include the local county and their take on the fair market value assessment. That adds up when you're talking about pounds of marijuana that are no longer being sold for $2,500 a pound. A lot of people don't want to say that out loud, but I will, because the price of marijuana is dropping to $1,000 a pound or even lower than that. And when you take $375 out of that, it is no longer a 15% wholesale tax. The fines levied by this board are also one that people have asked me to raise because they are of concern. They appear to be maxed out, and of one where they feel not related to the amount of severity, rapidity, or intent of the crime, but just the amount of things that you can list on a single sheet. We're getting the maximum charge for, but we would like to see that be more responsive to the knowledge of the owner of the license, or the ability to stop what happens from happening, to be the severity of the fine. Because otherwise, why are we always seeing the asking of the revocation of a license? And then finally, I would like to say the time and effort bills are one that have stacked up and become a concern for a lot of people in this industry. They come in drips and drabs, but they're one where we get digital audits and repeat audits that start adding up to becoming thousands of dollars per license holder in this industry. To take an example, you have a cultivation production in the same building, you will get time and effort bills that I'll read a few of here for each facility, and they do stack up repetitively. But I would ask that you guys understand that this is a big pain point for this industry, and one where it is of concern for many license holders. Will they stay open for the next year? Is that economically concerning for us with all these things stacking together? So I'd ask the board to please take into account these concerns, and maybe ask for a workshop of the board itself or a meeting of the advisory board if possible, because these concerns need to be vetted and need to be brought more to the public and more to your ability to address. So thank you for hearing these. And like I said, there just a few of these audits and concerns are concerned us with. We don't see a lot of relationships to time and effort with the time. A 420 spot check on camera in the building, 5 minutes. Time and effort charge 2 hours. Yes, there's 3 agents in the building, but they just said they had left a place down the street to come here. Yet we're paying a 2-hour time and effort charge, right? Inventory spot check, 14 hours, charged the first quarter of this year. Again, that is all that came in the line is 14 hours, time and effort. That's a $1,400 bill that one of our members has to pay. It goes on and on like this, but I would encourage you to please take these economic concerns seriously because they're serious to us and they are a big pain point for this industry. Thank you.
Thank
Have a
you.
good night.
Is there anyone else in Las Vegas wishing to provide public comment? Great, we'll move to Carson City. Is there anyone in Carson City wishing to provide public comment today?
There does not appear to be public comment in Carson City today.
Thank you. And as a reminder, we have received public comment, and we do receive public comment through email before meetings. That public comment is posted online. Any comment that we receive after we've posted or during the meeting or following the meeting will also be posted online once the meeting's done. So with that, Chair, I'll turn it back to you for agenda item number 2.
Thank you. Consideration for approval of the May 24th, 2022 Cannabis Compliance Board meeting minutes for possible action. If the members have reviewed, if we can get a motion or corrections.
Mr. Chairman, this is Member Nylander. I will abstain from voting on this matter. I had a family obligation last month and was not able to attend the meeting. So the record should reflect that I would be abstaining.
That'll be so noted.
Jerry Merritt, for the record, I move that we approve.
We have a motion for approval. Do we have a second?
This is Member Young. I'll second that.
We have a motion. We have a second. Do we have any additional discussion? Corrections? Hearing none. All in favor, please say aye.
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 I have 3 ayes on the record. Unless I missed some. Any that would deny? Any abstentions outside of Dennis? Motion carries. That moves us to our consent agenda, item number 3. We have 2 items on as to complaints. Turn it back over to staff.
Thank you, Chair. Item 3A on the agenda concerns 2 complaints for disciplinary action pursuant to NRS 678A510. The Attorney General has reviewed these violations and has recommended proceeding with disciplinary action. I'm requesting the board's approval to proceed with each of these 2 disciplinary actions, and if approved, I will then authorize service of the complaints. Once they are out for service, the CCB will post them on our website. So as to Respondent A, the complaint will allege violations of NCCR Regulation 4, violations of NCCR Regulation 5, and violations of NCCR Regulation 6. And as to Respondent B, the complaint will allege violations of NCCR Regulation 4. Chair?
As our normal comment on this, as to complaints, the board is not aware of the specific parties that are involved in the complaints. Per the NRS, it's been reviewed by the legal staff and the agency. And now they're asking for approval to make service of these items. So with that, do we have a motion as to complaints A and B for the record?
Jerry Merritt, for the record, I move to approve to proceed with disciplinary action for Respondent A and also for Respondent B.
We have a motion. Do we have a second?
I would
This is
second.
Member Young.
We have a motion. We now have a second. Do we have any additional discussion as to these items? Hearing none. All in favor of the motion, please say aye.
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 Any opposed? And no abstentions. Motion carries unanimously. We now come to item number 4, consideration of the proposed settlement agreements to resolve disciplinary actions. The first matter up this morning is Cannabis Compliance Board versus Helios Nevada LLC, 2021-46 for possible action. Good morning.
Good morning. For the record, I am Senior Deputy Attorney General Ashley Balducci, and I'll be presenting item 4A on the agenda. Item 4A concerns a proposed settlement agreement to resolve the CCB's disciplinary action against Helios NV LLC. As you may recall, Helios operates a medical and adult use cultivation facility in Reno, Nevada, Helios is one of the last cases, matters, or investigations that carried over from the Department of Taxation's Marijuana Enforcement Division to the Cannabis Compliance Board. As such, some of the violations alleged in the CCB's complaint occurred when the Marijuana Enforcement Division regulated the cannabis industry under Chapters 453A and 453D of the NRS and NAC. And some of the violations occurred after the transition of regulatory oversight from the DOT to the CCB, but prior to the CCB's adoption of the Nevada Cannabis Compliance Regulations, or NCCR. All the violations alleged occurred when a domestic corporation called Hydrovise International Incorporated managed Helios. Since the filing and service of the CCB's complaint, Helios has been controlled and managed by a court-appointed and CCB-approved cannabis receiver, Larry Birch. The parties have negotiated the stipulation order for settlement of the disciplinary action against Helios before you for your approval. Some of the key terms of this stipulation and order are as follows. In exchange for the CCB's agreement to not seek revocation or suspension of Helios's licenses, Helios admits to 1 Category 1 violation, 2 Category 2 violations, 3 Category 3 violations, 4 Category 4 violations, and 6 Category 5 violations. As discipline for the admitted violations, Helios agrees to accept a warning and pay a civil penalty in the amount of $120,750, the full civil penalty requested in the complaint, in consideration for its admitted violations. Helios may either pay the civil penalty in a lump sum within 30 days or in installments over a 6-month period. Helios also agrees to submit a transfer of interest application to the CCB for its review and approval to remove Kiera Sears and Wes Poleski as owners of Helios within 30 days of the CCB's approval of the stipulation and order. Ms. Sears and Mr. Poleski managed Helios through Hydrovise during the time the violations alleged in the complaint occurred. Helios further agrees to cooperate with CCB staff and counsel in investigating individual agent cardholders and make available any employees, owners, officers, and/or directors still under Helios's control to testify at any disciplinary actions against the individual agent cardholders. The stipulation order shall be considered discipline by the CCB against Helios. Helios represents and warrants that it has implemented corrective action as outlined in paragraph 22. To prevent the reoccurrence of the violations, which includes but is not limited to becoming and staying tax compliant, revising policies and procedures, hiring a chief compliance officer or similar position with experience to audit and monitor Helios's regulatory compliance, and continuing to have Mr. Birch, the court-appointed and CCB-approved cannabis receiver, supervising the operations of Helios until Helios has completed all terms of this stipulation and order, or unless otherwise approved by the CCB. Once all terms have been fully performed, the CCB's administrative action against Helios will be closed. With that, I will turn it over to Mr. Charles Gentiloni. I'm sorry, I probably mispronounced it, but I tried. Counsel for Helios and the cannabis receiver, Mr. Birch, who are here in person, and the cannabis receivers counsel, Ms. Tracy Osteen, who's appearing via Zoom, to answer any questions you may have. The Attorney General's office recommends and requests the board vote to approve this stipulation in order for settlement of disciplinary action against Helios in CCB case number 2021-46. Thank you.
Comments on behalf of Helios this morning? Good morning.
Good morning. Good morning, everyone. Again, Charles Gentiloni on behalf of Helios. Just a couple of very brief comments. This has been a long and difficult process, of course, that's been going about 10 months that Helios has lived this. We certainly appreciate the cooperation with Ms. Balducci and Mr. Rath. Although they were tough, there was a lot of back and forth on this one. There was a lot of negotiations, but we feel that this settlement is something that Helios can live with and will allow it to survive and hopefully prosper in the future. Things were tough, and then in February, when Mr. Birch was approved to be the receiver, he came in and, took large strides to get Helios to where it is now. I am happy to report that as of Friday morning, Helios became compliant with all of its tax obligations with a very large check that went to the Department of Taxation Friday morning. So again, that's just one example. We certainly talk about the other things that Helios is doing, but it's well on its way. And again, Helios believes that this is a fair settlement agreement, everything considered. And then if Mr. Birch wants to speak.
Mr. Birch.
I appreciate the cooperation of the staff with the CCB so we could get this behind us and move ahead. And I appreciate that very much.
Thank you. Questions of board members as to the settlement from either our staff or the licensee? And we appreciate, go ahead, Dennis.
I'm sorry, Mr. Chairman. So just to confirm, paragraph 22 of the settlement is the corrective action plan. And so you've got that in place.
Good morning. My name is Georgina Miller and I'm with the Lightwater Group. I act as compliance officer and management firm for Helios, Nevada, and I can say that we have put those corrective actions in place. Our plan of corrections will be issued to the CCB within the week. I have updated 45 SOPs, internal audits, and quality controls.
Great. Thank you for that.
You're
I
welcome.
did not have any other questions, Mr. Chairman.
Thank you. Any other board member? If not, can we have a motion?
Mr. Chairman, I would move for approval of item 4A on the agenda as it's reflected on the agenda for approval of the settlement agreement.
Thank you.
Jerry Merritt, second.
We have a motion. We have a second. Do we have any additional discussion? Hearing none, we have a motion for approval of the stipulation and order for settlement of the disciplinary action as a Helios Nevada LLC. All in favor, please say aye.
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 Matter carries unanimously. Thank you very much.
Thank you very much.
Thank you.
We now move to item B, Cannabis Compliance Board versus Mesa Oils LLC, case number 2022-77.
Good morning, Chair, members of the board. L. Christopher Rath, Senior Deputy Attorney General. I'll be handling item 4B, which is CCB versus Mesa Oils LLC, CCB case number 2022-77. This matter arises from the TOI investigation that was presented to the board at its December 2021 meeting. At that time, the board considered a TOI involving changes in Mesa Oil's ownership interests. The TOI investigation uncovered evidence indicating the requested transfer had already taken place effectively prior to CCB approval of the TOI request. At its December meeting, the board unanimously approved the TOI, but referred the issue of the potentially unapproved TOI back to the CCB staff and the Attorney General's office for further review and to see whether resolution on this issue could be reached. After further review by CCB staff and the AG's office, the parties initially came to an agreement on the unapproved TOI issue. However, matters were further complicated when Mesa Oils reported a new issue in March 2022. Specifically, Mesa Oils revealed that it had come to realize that one of the new owners of Mesa Oils under that TOI, which was RKA Investments LLC, had not reported its full membership in the TOI application submitted to the board. Thus, there were two owners within the RKA Investments LLC who had not undergone a suitability investigation and were essentially hidden owners. As a result, further negotiations were undertaken to try to resolve this new issue along with the first issue that had been found. The parties were successful in reaching such an agreement, which is contained in the settlement agreement before you. As noted in the settlement agreement, Mesa Oils has waived the filing and service of a complaint to resolve these two issues and has agreed to accept a Category 2 violation for affecting a change of ownership interest without meeting the board's requirement for approval of a transfer of interest, and a second Category 2 violation for making an unintentional false statement to the board. In addition, Mesa Oils further agreed to pay a civil penalty of $63,000 and submit a corrective TOI application to the CCB within 30 days of approval of the stipulation in order to correct its ownership structure and allow for the full suitability investigation to take place on the two unknown individuals. I will note that the civil penalties do take into account that the second issue was self-reported, albeit late, and that the maximum penalties for two Category 2 violations would have been $100,000 and a 50-day suspension. And, the other violation could potentially have been pled as a higher Category 2 in a complaint. Paragraph 22 of the settlement agreement summarizes the respondent's plan of correction, and the CCB staff has approved this. In summary, respondent has updated its standard operating procedures to confirm that no proposed transfer of interest will be carried out in any way until there has been full CCB approval. Mesa Oil's members will be required to cooperate fully with CCB staff in TOI investigations and ensure they provide accurate and truthful statements during such investigations. And as previously noted, a corrective TOI application will be required to be submitted within 30 days if the settlement agreement is approved. The CCB staff and the Attorney General's office agree these admitted violations, the civil penalty, and the corrective actions taken appropriately address their areas of concern that the licensee has been fully advised about and understands the gravity of these issues. As a result, the Attorney General recommends and requests the CCB approve this settlement agreement. I'm available for any questions, as is the licensee and their counsel.
Thank you. Comments at this time from Mesa Oils or from Mr. Connor as counsel?
Good morning. Thank you, Chair Douglas, members of the board, Director Klimas, Derek Connor, law firm of Connor and Connor on behalf of the licensee, Mesa Oils LLC. Also with me is a representative of the client, Mr. Paul Schloss. I believe Mesa's manager, Mr. Harris Ridoff, should be attending via Zoom. I'm not sure if he's on, but I believe he's out there. Harris, can you hear us? It doesn't appear that he's able to respond at this time. Oh, is he?
Hello.
Oh, there he is.
Good morning.
Good morning, Harris.
You have to forgive me. At 87, I'm still learning how to turn my Walkman on.
Thank you, Harris. As you can hear, my client is a little bit older than some of us, and we love him to death. I also want to thank Mr. Rath, and I believe Ms. Balducci and Ms. Breedlove worked on this matter. I think that Chris did a good job summarizing the facts of the case. I do want to clarify one thing that Chris said. He said that we self-reported this. That is correct. I think he said that it was late. I think he means probably after the TOI, but I want to be very clear to the board. We self-reported this the instant we found out about it. We wanted to make sure that we were upfront and honest with the board, and that is exactly what we did. I'm prepared to answer any questions that any of the board members or staff may have for us regarding the settlement agreement. And with that, I'll turn it back over to you.
We note for the record, as Mr. Rath has put forward, there's a plan of correction in terms of your SOPs, your standard operating procedures, so that you don't have this kind of problem in the future. As painful as it may be at this point. Anything on behalf of from the license managing.
Thank you, Chair Douglas. Yeah, we will definitely ensure that we put in place the steps that will not allow this to happen again.
Questions by any board member?
I have a question. So can you explain the self-reporting aspect, the timing of it? Because wasn't this uncovered when the transfer request was submitted?
No, Member Durrett, it was not. So we submitted a TOI request adding basically 50% new members to Mesa Oils that were transferred. Ownership was previously held by Mr. Ridoff through a separate LLC called HRSC LLC. It's subsequent to that approval. There was, it was referred back to staff, like I think Mr. Rath said, and there was determined, we basically negotiated an agreement that there was at least possibly an unapproved TOI for that initial transfer of interest application. We had reached a settlement agreement on that. After that, it became clear, company was made aware, of which it had previously had no knowledge, that a member of Mesa Oils, RKA Investments LLC, was actually a 3-member LLC. We had been led to believe, in fact, when the TOI was submitted, they signed a notarized affidavit stating this was correct. So we believed that that was correct. We learned that it was not true, and we immediately, I think within like the day, I contacted Mr. Rapp and reported it to him. So that's how the timeline of that happened.
Mr. Rath, does that sound correct to you? And I think I want to highlight that I've been waiting for a self-reporting one to come up because I am very much in favor of lower fines on self-reporting and sending a message to the industry that self-reporting is good. So if Mr. Rath agrees that's the occurrence of events, I would be in favor of reducing this. I might be on my own, so I will not make the motion, and I just would not support this amount.
Just for further information, Member Durrett, the TOI was approved in December. The self-report was in March of 2022, so it was well after the TOI was approved. It was a self-report, but there's also an issue there with whether the licensee checked through its application and did its due diligence to check out to see whether all the LLC members had been accounted for. And we did take into account, as I said, the self-report. Normally, this would be a much higher penalty.
Thanks.
For the record, Chair Douglas, this is one of our normal conundrums. We as a board and the agency, we're only as good as the information provided to us. We understand from the licensee standpoint, management at the time did not create this problem. However, somebody who was attempting to join their management created the problem.
Correct.
That got us here today. So I understand Member Durrett's concern as to this and a lower penalty. However, the other alternative almost is to exclude the party who wants to join for their misstatement. So that's our conundrum. Even though we do give them, Mr. Rath is saying that he did understand in the negotiations as to possible penalty in this self-report, in which we do applaud. But how do we deal with someone who has done an action which is inappropriate? And it's a shame that we have to, in essence, penalize a licensee who has done the right thing.
I agree fully.
So that's my statement for the record. But having said that, if any other board member wishes to weigh in, please do so, so that we can resolve this matter.
Well, this is Member Nylander, and I do appreciate that you self-reported Mr. Connor. And I agree with Member Dredd in that respect, that we, that's what we're looking to do, is to have the industry be more self-regulated so that we don't, have to do these things. But on the other hand, I also, in terms of due diligence, you got to know if there's 1 or 3 members of an LLC that's trying to join the company. So, I mean, yeah, I think it's a fair settlement in my view. But what sort of due diligence do you have in place? Like, how did you not know that there were 3 members of this LLC instead of 1?
I believe when they initially negotiated this transfer, and I don't recall if we were directly involved. I know we weren't involved in the negotiations. We were told by the manager of that entity that it was a sole member entity. And in the course of that, we relied on those statements. And as you know, when you submit a TOI, these members are signing under penalty of perjury a document stating that everything in the foregoing is 100% correct. I guess say, fool me, shame on us for not digging deeper into this and taking somebody at their word, but that's ultimately what they did. They took a man at his word. They believed what he said was correct, and we relied on that, and now here we are. In the future, obviously, I will definitely put them on the rack. Every share out of them that I can get.
Okay, no, understood. Thank you for that.
Thank you.
Any other board member wish to weigh in at this question or a comment? If no other board member wishes to make a statement, does a board member wish to please make a motion?
Jerry Merritt, for the record, I move that we approve consent agenda number 4B.
We have a motion for approval of the stipulation order for settlement of disciplinary action. Do we have a second?
This is Member Young. I'll second that.
We have a motion. We have a second. We have any additional discussion? Hearing none. All in favor of the acceptance of the stipulation order for settlement of disciplinary action, please say aye.
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 Any dissent?
Chair, I'm a no for the reason I stated.
Okay.
Thanks.
Motion carries. We note the one dissent, the reason stated. Motion carries. Thank you very much.
Thank you all members of the
Thank you.
board and staff. Again, thanks, Chris. I appreciate the opportunity to be here today. Thank you.
Thank you.
That now takes us to item number C, Cannabis Compliance Board versus Silver Sage Wellness LLC, case number 2022-78.
And good morning, Chair and members of the board. This is Senior Deputy Attorney General Mike Debner for the record. Presented for the board's consideration today under item 4C. Today's agenda is a proposed settlement agreement under case number 202278 CCB v. Silver Sage Wellness. This matter arises from a disciplinary complaint that was filed and served on the respondent on or about March 29th, 2022. The violations alleged in the complaint include, in summary, a Category 2 violation for failing to maintain required surveillance systems and multiple Category 3 violations for storing cannabis products outside the seed-to-sale tracking system and failing to meet requirements for the disposal of waste. As of the date of this hearing, the respondent has not filed an answer to the complaint since shortly after its service, the respondents reached out to engage in negotiations for possible resolution of this matter. The parties thereafter engaged in settlement discussions, which resulted in the agreement that is before the board today, board's consideration. The terms of this agreement include respondents' admission to one Category 3 violation for storing or delivering an unapproved cannabis product or cannabis product outside the seed-to-sale tracking system, and a second Category 3 violation for failing to meet requirements for the disposal of cannabis waste. A respondent's agreement to pay civil penalties totaling $50,000 within 30 days of the board's approval of this agreement, should it choose to approve it. And respondent also provided a plan of correction, which is detailed in paragraph 18 of the agreement, and which CCB staff has approved. In summary, this plan of correction included the following terms. The termination of the primary employee that was involved in the violations concerning improper storing and disposal of cannabis, retraining for those other employees which were also involved in those violations, but to a lesser extent. And respondent also updated the standard operating procedures concerning the proper storage and disposal of cannabis, which were deficient in preventing the violations, and trained its employees on the same. This, of course, is just a summary of the primary terms of the agreement, with the full terms being provided within the document itself. Based on the facts of the case, the aforementioned corrective actions and the respondent's admissions to the violations, the Attorney General's office recommends that the CCB approve the agreement. I'm available to answer any questions as well as counsel for the respondent, and I believe a representative of the respondent as well. And with that, I submit.
Thank you. We have a representative this morning and we have counsel.
Good morning, Mr. Chairman, members of the board, Director Climas, Mark Ferrario from Greenberg Traurig, appearing on behalf of Silver Sage Wellness. My left is Mr. Joy, representative from Silver Sage. I really don't have anything to add other than to thank the Attorney General's office, Ms. Balducci and Mr. Detmer, for their professionalism and their ability to jump on this and resolve it quickly. And I think we have a fair settlement, and I would ask that.
Anything on behalf of the licensee representative? No. Questions or concerns from any board member?
No, this is Member Nylander. Mr. Ferrario, if you say it's fair, it has to be fair because.
Thank you, Member Nylander.
And it's nice to see you again.
It's good to see you as well.
Can I make a comment as well? I just want to add as a mitigating factor, although since the respondent is saying that it's fair and they want to enter into it, I imagine that we will, that this respondent, when I worked with them in the past, any charitable event that came up, they were the first to contribute. They collected a significant amount of masks, contributed money. Their owners have been known for contributing charitable causes significantly. So have a lot of the licensees. So I just wanted to throw that in there.
Thank you.
Chair Douglas, for the record, comment. We note the plan of correction, item number 18 in the stipulation, which points out to all licensees the importance of keeping their staff trained and up to date on policies and procedures to ultimately keep the licensee from being before us. Again, as we are only as good as information provided to us, you are only as good as your employees that work for you and do the day-to-day transactions.
That's correct.
And you bear the burden for their shortcomings, unfortunately. With that, do we have a motion as to the stipulation?
Jerry Merritt, for the record, I move that we approve consent agenda number 4C.
We have a motion for acceptance of stipulation order for settlement of disciplinary action. In this case, do we have a second?
I would second the motion.
We have a motion, we have a second. Do we have any additional discussion? Hearing none, all in favor of the stipulation order for settlement of disciplinary action, case number 2022-77, please say aye.
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 Thank you.
Motion carries. We have no dissent.
Thank you.
Thank you.
Good to see you, Member Nylander. Take care.
That takes us to item number 5, request for transfers of interest. First matter up, item A, ACC Enterprises LLC. Possible action.
Good morning, Chair Douglas, Member Merritt, Member Nylander, Member
Yes.
Durrett, and Member Young. For the record, I am David Staley.
Mr.
Division
Staley, if
Chief.
I can have you hold off just a second. If we have parties, let them get in place. And
Yes, sir.
Morning, Chair, Board. Stephen Mack on behalf of Strata Growth. With me is Darren Kessler, who is the owner of Strata Holdings, which is the owner of Strata Growth.
good morning.
Good morning, Chair Douglas, members of the board. John Savage on behalf of William A. Leonard, the court-appointed receiver for ACC Enterprises LLC. Mr. Leonard is present today as well.
Good morning, Chairman. Good morning, board members. Good morning, board members. Adam Fulton on behalf of ACC.
Thank you.
Good morning, Mr. Chairman, members of the board. For the record, I'm David Staley, Division Chief of Investigations for the CCB. Item A is a TOI application for ACC Enterprises LLC, or ACC. TOI number 22004 requests approval for Strata Growth, or Strata, and its owner, Darren Kessler, to acquire ACC and its cultivation licenses in Pahrump, Nevada. ACC was placed into receivership by Megan Konechny after the death of her husband and ACC owner Howard Meisel. Kessler, through Strata, was the sole bidder for ACC during the receiver's asset auction. Staff identified areas of concern with TOI 22004 because ACC completed unapproved transfers of interest, failed to tag all plants, and failed to timely submit tax reports and/or payments. With regard to the areas of concern, CCB staff have With regards to the areas of concern that CCB staff have identified, the Attorney General's office is currently working with attorneys for ACC, Strata, and the receiver to complete a mutually agreeable global settlement agreement that would cover the resolution of the areas of concern, as well as other pending issues and litigation subject to board approval. If the board is inclined to approve this TOI request, such approval should be conditioned on the board's subsequent approval of that global settlement agreement. In that case, the TOI would be approved subject to approval of the global settlement agreement, and the TOI would not be effective unless and until the board approved that global settlement agreement and the receivership court has also approved that global settlement agreement. I am available for any questions, and the members before you are available for questions as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. With that, representations.
Your Honor, we agree with staff. We would like this commission to approve the transfer of interest subject to the entering of the stipulated settlement agreement. And we're just about there. If I'm not mistaken, Mr. Rath and I have been talking about it, and we've come to the amounts. It's just really just how the payment schedule is going to be on it. So I think we could have it done here fairly quickly and hopefully done with a special and get this done before the end of the month or before the end of July.
Thank you. Any other comments?
Chair Douglas, members of the board, Director Climas, John Savage, on behalf of the receiver, I just want to thank staff and Mr. Rath for working with us on this. It had a lot of negotiations and several drafts back and forth, and we appreciate his time and effort. We are in support of getting conditional approval subject to the final settlement agreement. And once we do have that final settlement agreement, we'll be filing a motion for receivership court, hopefully on order shortened time, if the court would grant that request to get these settlements.
Yeah, we have before us as well the proposed settlement, and as you said, the terms are not fully worked out. We have a purchase by Strata of ACC's assets, payments, as to some tax liabilities, release of claims, release of receiver certificate of independent value of a product, and assumption of certain liabilities and specific terms because they're not fully resolved at this point. And they're asking for kind of a conditional approval today because it still has to be approved by tax and the court. So it's moving pieces in that. Any additional comment by our staff, our council?
Thank you, Chair. I agree. We are very close on global resolution, but it will take a little time given there's additional parties to that settlement agreement.
Board member questions? Hearing none. Do we have a motion at this time?
Mr. Chairman, this is Member Nylander. I would move for approval of agenda item 5A as reflected on the agenda, and that approval will be conditioned that the transfer not occur until there's a global settlement agreement, as Mr. Rath indicated.
Thank you. Do we have a second?
Member Merritt, I second.
We have a motion and a second. Do we have any additional discussion or questions? Hearing none. All in favor of the proposed TOI and global settlement on a conditional basis at this time?
Aye.
Say aye.
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 Matter carries unanimously. Good luck with concluding this.
Thank you very much. We appreciate it.
Thank you.
That takes us to GPS Nevada Partners LLC, TOI number 21020, DO 15 RD 015. Good morning.
Good morning, Chair Douglas, members of the board. Neil Tomlinson. I'm here on behalf of GBS Nevada Partners, the Maservi Family Trust, and Green Cross Investors. I've got with me Mr. Jim Maservi, daughters Jillian and Gianna. And then also with us today is the managing member of GBS Nevada, Mike Billion.
Good morning. On behalf of the board.
Good morning, Chair Douglas, members of the board. For the record, I'm David Staley, Chief of the Investigations Division for the CCB. Item number B is the TOI application for GBS Nevada Partners LLC, or GBS. TOI number 21020 was filed by GBS requesting approval for the internal restructuring of the 27.59% ownership of the Meservey Family Trust into Green Cross LLC, then adding Jillian and Gianna Meservey as new members of Green Cross LLC. Staff identified an area of concern with TOI number 21020 because GBS filed late or incomplete tax returns with the Nevada Department of Taxation 3 times during the last 3 years. CCB staff have provided potential options for the board's consideration to proceed with TOI number 21020. I'm available for any additional questions you may have. Chair Douglas, I'll turn this item back to you.
Council, on behalf of our licensee.
Yeah, thank you, Chair Douglas, members of the board. Again, Neil Tomlinson for the record. So this transfer of interest, it's an intra-family transfer. So the Meservey Family Trust has an ownership percentage in GBS Nevada. They are proposing to transfer into a LLC, and then from that LLC to include both the Meservey daughters with a small amount of ownership of their stake in GBS Nevada. So that's both Gianna and Jillian who are here today, and they've of course submitted all of their background checks and agent cards and all of that. And I believe everything is in order with respect to the late tax payment. We have a letter of good standing from Department of Taxation from May 2nd, 2022. Apparently there was one instance where there was a check that was submitted that was not received apparently by Department of Taxation. Check was reissued and received. And then 2 others were submitted timely, however, they were processed by Department of Taxation late. So it was really just clerical mistakes on all of these. Everything is current and up to date. GBS Nevada has the outstanding regulatory record and, like I said, current good standing with Department of Taxation.
Thank you. With that, questions, board members, or statement as to this TOI?
So I just want to, just for the record, this is Member Nylander, just for the record to make sure that you are indicating that the taxes are current now with Department of Taxation.
That is correct, Member Nylander.
Okay. Thanks, Mr. Tomlinson. And I would also just say, it's very impressive background. These owners and principals have contributed a lot to Las Vegas over the years. And I think this seems like it's a ministerial error, clerical error, I guess is another way to put it. But and I don't have any further concerns on this application.
If there are no other questions, can we get a motion?
Jerry Merritt, for the record, I move that we approve consent agenda number 5B, GBS Nevada Partners LLC for transfer.
What that would be a note that we're finding no violation this time.
Yeah.
Thank you. We have a motion. Do we have a second?
Member Durrett, I second. And this, just to clarify, this is not being sent to the AG for further discussion.
That's why I added that additional language.
Okay, thanks. I second.
It's been moved and seconded. All in favor, please say aye.
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 Matter passes unanimously.
Thank you, Chair and board members. I'd be remiss if I didn't also thank staff, especially Rachel Prince and Chief Staley for helping us get this through. Thank you.
Thank you. That takes us to item number 6, request for consideration of approval of management services agreement.
One more C.
I'm sorry. As I was prompted, WSCC Inc., TOI number 20003 21041, 2100009, 210050, C098, RC098, C099, RC099, P071, RP071, and D111. And RD111, D149, and RD149, and T091 as related to Verano Holding Corp.
Chair Douglas, members of the board, for the record, David Staley, Chief of the Investigations Division. Item C are the TOI applications for WSCC Inc. or WSCC and Verano Holdings Corp. or Verano. TOIs number 20003, 21041, 2100009, and 2100050 were filed by WSCC and Verano requesting approval for WSCC internal transfers and ultimately for Verano to acquire WSCC. An early suitability review for a lounge license was completed in conjunction with the investigation for these TOIs. The investigative report concluded that Verano is not only suitable for the requested TOIs, but is also suitable for a potential lounge license. The early review did not include specifics related to the operation and location of its proposed lounge, which will still need to be investigated by CCB audit and inspections after the lounge application period, along with a brief update from CCB investigations. In addition, Verano has requested waivers pursuant to 5.112 and 5.125 of the requirements of NCCR 5.110 regarding a review of owners related to transfers of under 5% and aging cards. Staff suggests that if approved, the board limit such waiver to expire on the next agenda date for a Verano transaction. Staff identified an area of concern with these TOIs because WSCC filed late or incomplete tax returns with the Nevada Department of Taxation 11 times during the last 3 years. CCBF staff have provided potential options for the board's consideration to proceed with these TOIs. I am available for any questions, and my understanding is that Amanda Conder, James Leventis, George Archos, John Tipton, Stephen Nightingale, Fernando Leal, and Duncan Burke are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
And if I'm just a note, your report indicates that the amended returns were filed and that additional taxes, including penalties, were paid in this case. Is that correct?
Yes, sir.
Ms. Connor?
Good morning, Chairman, members of the board. I am here on behalf of my clients. I represent WSCC as well as Verano Holdings. We appreciate Dave Staley and all of the work he did, as well as Investigator Cole in doing the investigation. As the board may remember, Verano was in front of you last month for a transfer of interest approval, and we had to pull out WSCC because there was not a waiver of the notice of the meeting. So we are here to complete the full acquisition that Verano had proposed. As noted by the chairman, the taxes that were late filed, they did file returns and pay any late penalties and interest. They recently, WSCC renewed its licenses, and as a part of that had to receive letters of good standing from the Department of Taxation. And therefore, my understanding is that they are current on their taxes. And we would kindly request approval of this transfer of interest via Zoom is Mr. Leventis. I would like to congratulate him on his newborn baby. That is why he is appearing via Zoom, but he is available on behalf of Verano to answer any questions you may have if needed.
With that, unless there's something the representative licensee wishes to state, board members' questions, if any. If we have no questions, do we have a motion to this request for transfer of interest?
Mr. Chairman, I would move for approval of item 5C as reflected on the agenda. And I also wanted to just make a comment that, again, the ownership of this company is very impressive. They've done a lot, in the communities where they live, and I think that's an important thing just to point out. But we would also want to condition the approval that the waiver pursuant to 5110 and 5125 would expire on the next time that veranda comes on the agenda. Did I butcher that sufficiently enough?
I think it gets us there. With that, we have a motion. Do we have a second?
Jerry Merritt, for the record, I second.
We had someone else who wished to weigh in? We have a motion. We have a second. Motions for granting with the waiver provisions. With that, all in favor, please say aye.
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 Aye. Rihanna, you're on mute.
Oh, aye, sorry.
Thank you. Matter passes unanimously. Thank you.
Thank you, board, and thank you to the staff.
Since I was premature previously, item number 6, request for consideration of management service agreement as to Two Skirts Cultivation and Production LLC, C190, RC190, P125, RP125, and West 118 Investment LLC for possible action. Good morning.
Good morning, Adam Fulton on behalf of West 118 and on behalf of Two Skirts Cultivation and Production LLC.
Chair Douglas, members of the board, for the record, I'm David Staley, Division Chief of Investigations for the CCB. I'm here to present agenda item number 6, which consists of one management services agreement, or MSA, between Two Skirts Cultivation and Production LLC and West 118 Investments LLC. CCB staff have reviewed the agreement and found it appropriate. I'm available for any questions, and my understanding is that Adam Fulton, Hassan Asori, Madeline Castor, and William Ross are present today to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Any representations, Mr. Fulton?
No, we'd just like to thank staff again for their assistance with this matter. Thank you.
We understand that based upon the report, this management services agreement is part of proposed sale transaction. Is that correct?
That is correct.
Questions by board members? If no questions, do we have a motion?
Jerry Merritt, for the record, I move that we approve consent agenda number 6, request for consideration of approval of management service agreement between Two Skirt Cultivation and Production LLC and West 118 Investment LLC.
We have a motion for approval. Do we have a second?
Is Member Young, second that?
It's been moved and second. Any additional questions or discussion? Hearing none, all in favor, please say aye.
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 Durrett. Member Durrett, did you?
Yeah, I said aye.
Okay, thank you. Matter passes unanimously. Thank you.
Thank you very much.
That takes us to item number 7, request for consideration of approval of waiver of NCCR 5110 pursuant to NCCR 5.125 as to G5 Cultivation LLC, TOI number 21073 C075 RC 075.
Chair Douglas, members of the board, for the record, I'm David Staley, Division Chief of Investigations for the CCB. I'm here to present agenda item number 7, or TOI 21073. This item consists of one application by G5 Cultivation for a waiver of the requirements of NCCR 5.110 pursuant to 5.125. But as a matter of course, we have been using the TOI numbers to track all of the different applications. So while this does have a TOI number, it is a waiver, a request for a waiver only, not for a transfer of interest. G5 has adequately addressed the items required in NCCR 5.125 to allow the board to approve such a waiver. Staff suggests that if approved, the board limit G5's 5.125 waiver to expire on its next agenda date. Staff identified an area of concern with TOI number 21073 because G5 filed later incomplete tax returns with the Nevada Department of Taxation 5 times during the last 3 years. I am available for any questions, and my understanding is that Larry Smith, Diedrich Holman, and Maribel Mendez Gomez are present today to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. If you would introduce yourself and any representation.
I'm Larry Smith, owner of G5 Cultivation.
I'm Maribel Mendez Gomez.
Good morning.
Good morning.
Any representations you'd like to make as to this matter?
No.
Questions by the board?
So for Mr. Smith, just to verify that you are in compliance with the payment plan now on the tax
Yes,
issue?
we are. Yes.
Any other questions by any other board member?
And for Mr. Staley, I'm just trying to understand that. So we had the wrong number assigned on this?
No, Member Nylander, we are using TOI numbers to track all of the applications that come before the board. So while this is a TOI number, it is not a transfer of interest.
Okay, I understand. Thank you.
But yes, sir.
Do we have any motion that a board member wishes to make as the possible approval of waiver of NCCR 5.110 pursuant to NCCR 5.125?
Mr. Chairman, I would move to approve item number 7, G5 Cultivation LLC, and the approved waiver of NCCR 5.110 pursuant to NCR CR 5.125 is conditioned to expire on the G5 Cultivation's next agenda date.
Thank you. Do we have a second?
Jerry Merritt, for the record, I second.
It's been moved and seconded. Any other discussion? Hearing none, all in favor, please say aye.
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 Matter carries unanimously. Thank you very much.
Thank you so much.
Thank you.
We next turn to what was posted as agenda item number 8, Cannabis Compliance Board versus Faith Crosby, case number 2022.58. That matter is a stipulation order to state administrative proceeding that's been accepted and entered into the state. So the matter will go off calendar pursuant to the stipulation. What I'd like to do is real quickly go to item number 10, approval and resolution as to notice of final licensure, New Leaf CLV Dispensary LLC D069 RD069. Get that information I'm taken care of.
Good morning, Chair, members of the board. Steve Gilbert, Chief of Administration, for the record. Agenda item 10A is an informational item presented as a notice to the Board of Establishments that have been issued their final license since the last board. We have one license to note today. In August of 2018, New Leaf CLB Dispensary LLC, or New Leaf B069, was issued a provisional license for a medical dispensary license in the city of Las Vegas jurisdiction by the Department of Taxation. New Leaf applied for and was granted a conditional adult use retail store. So on September 21st, 2018, RD069 in the city of Las Vegas jurisdiction by the Department of Taxation. New Leaf applied for and was granted an extension to the February 5th, 2022 final inspection deadline by the CC at the December 14th, 2021 board. On March 29th, 2022, CC conducted a pre-opening inspection and audit at the facility located at 1600 Las Vegas Boulevard South, Suite 150 in the city of Las Vegas. The inspection and audit results revealed the facility was in compliance with Nevada Cannabis Compliance Regulations and Title 56 of the Nevada Revised Statutes. The statement of deficiency was issued on March 30th, 2022, demonstrating New Leaf has met the regulatory operational requirements. As a result, the CCB approved and issued final license to New Leaf B069 and RE069 on May 20th, 2022. With that, Chair, members of the board, I'm happy to answer any questions.
As of this item, it's for information only, but do board members have any questions they wish to raise? If there's no questions, accept that report. Thank you very much. Before we take item number 9, consideration of proposed adoption amendments and or repeal of the Nevada Cannabis Compliance Regulations, I'd like to take a very curt 5-minute break. We'll come back because this will take some time. With that, we'll go off the record for 5 minutes. New media, different channel.
Got the other members.
Member Nylander, Member Durrett, do we have you back?
I am here.
I'm here.
Fantastic. Great.
Just for the record, if, go back and just call the roll to make sure we have a quorum for the record.
Sure. Member Merritt,
I'm here.
Member Durrett,
Here.
Dr. Young,
Present?
Member Nylander,
Here.
and Chair Douglas.
Here, that's, for the record, we have a quorum of the board, so we can continue with our business. We are now at, as indicated, item number 9, which seems to be why everyone is here. Consideration for proposed adoption amendments and or repeal of Nevada cannabis compliance regulations. We have a number of breaks in here in terms of segments for those who have an agenda. I'm going to ask if you have general comments that you wish to make, allow you to make it up front. If you have specific comments, I'd ask if you'd hold it until we get to the section, the regulation comes up that pertains to comment. Still allow you to make your comment, so we obey the open meeting law. With that, I don't know if we got any new public comment on the record this morning since we opened our meeting that pertain to this area.
Chair, I don't believe we did. We received 3 public comments and those have been posted online, I believe. Staff can correct me if I'm wrong.
All right, general public comment as overall, anyone wish to make a statement?
Good morning. For the record, Chris Anderson with Sala Consulting on behalf of Planet 13 Holdings and Hardeen Cannabis Dispensary. I just want to thank the board and staff for all of their hard work on these regulations, and we are fully supportive of the entirety of these proposed regulations, and hopefully look forward to passage this morning. Thank you.
Thank you. Anyone else in Las Vegas with a general comment? Mr. Hawkins? No Raider jersey this morning?
No, we got a few things. We got to win a few games first. But right now we're undefeated. Super Bowl contender. Thank you. My name is Frank Hawkins, Nevada Wellness Center. And general is appropriate now to speak to 1, 2, and 3 of Regulation A, or should I wait?
Wait on that.
Okay.
Okay. Any other general comments? If not, moving to Carson City, do we have any general comments as to what's before us? That being
No
the
general
case,
comments.
thank you. We'll get down to brass tacks.
Okay, good morning. My name is Michael Miles, Deputy Director of the Cannabis Compliance Board. These amendments and additions to the NCCRs are broken into 2 categories this morning. First are the application regs, which are comprised of changes to Reg 1 and Reg 5 of the NCCR. As the name implies, this covers the consumption lounge application and suitability investigation process to include the requirements of a diversity plan and the process needed to apply as a social equity applicant. Second will be the operational consumption lounge regs, which are comprised of changes to regs 1, 4, 5, 6, 9, 10, 11, 12, 13, and the addition of new regulation 15. The operational consumption lounge regs cover all aspects of operation to include sales limits, security, notice, warnings, signage, and label requirements, cleanliness, inventory, ventilation, location requirements, and plans to prevent driving under the influence. I'm going to briefly discuss the main changes, very briefly discuss the main changes made since the last workshop. The main change to the application regs is the aforementioned is the inclusion of how to handle the grandfathering process found in NCCR Reg 5 5.040 subsection 1E1. Again, there's been some discussion on this, and we're going to have a little more discussion on this grandfathering process. Does any member of the board have any questions as to these regulations?
is there more language than what was sent out previously, or is what's in front of us the current proposal?
What's in front of you is the current proposal.
Thanks.
With that,
And
have-
just for the record, if Deputy Miles could sort of summarize what the current proposal is in front of us.
To the current proposal for the grandfathering?
Yes, please.
It's all set on the time frame. Right now, it's set that the cannabis. This is just for cannabis sales facilities. Cannabis sales facility applying for a retail consumption lounge license has to show that it met all distance requirements under the law in effect on the date the sales facility received its final license to operate, which means did its final inspection, got approval from the CCB to open and operate. If they can
Okay.
show that, then it's grandfathered in. That's the process that's in place right now.
Okay, thank you.
That is what is on before us at this point. I will say that I have some concerns as to the portion of the language 5.040. As to the language where we have the cannabis sales facility receive the final license to operate, I think we would be better served to follow the language that was put forth in 678B 250 that says existed on the date on which the application for the proposed adult use cannabis establishments was submitted to the board. That complies with the statutory language that's in effect. Whether that is acceptable to other members, that's something that we'll get down the road. But having said that, I don't know if any other board member wishes to make any statement this time before we entertain comment as to any of the regulations in this first half. If they wish to do so, if you wish to make a statement, or if you wish to hold it till we've heard all the other public comment. And I know this is a very interesting issue because of different viewpoints on how this works. With that, we'll open it up to public comment. This would be appropriate, Mr. Hawkins. Remarks.
Hello again, my name is Frank Hawkins. As it relates to the grandfathering, and as I understand it, so the current licensees, when they were licensed, the date either by this board or the state health or taxation would be grandfathered in. As of the date that they applied and were awarded their application, were awarded their license. Okay, I concur and I can support that. Thank you. Now, are we still on grandfathering or are we on the next item?
This is everything in the application.
Everything, okay.
Everything in the application.
All right,
So you can bring a lunch and.
thank you,
stay for a
yes.
while.
I appreciate that. And I want to as well thank everybody and staff for all their hard work. I know it's not easy. There's lots of moving parts and we have experienced it. But thanks to the board and the staff, we now have two dispensaries and a cultivation. So we are working hard to do the right thing. And just want to say thank you again to you all. But I want to speak primarily and specifically to the social equity for consumption lounges, because I see and hope that that is where the immediate new licensures are going to occur, and the opportunity for folks that look like me that want to be in this business is an opportunity to get in based on your social equity requirements. There's a few, I care about the application, because if people don't get past the application, they're not going to get a license. So all of the other stuff I don't have a problem with, but I want to make sure that those that don't have lawyers, those that don't have consultants, those that can't afford to pay people a lot of money, that they understand what it's going to take and what they have to do. So my first question is, I asked, recommended, or suggested that maybe when the application does come out, that there is a period that folks can come together when they see the application and ask questions. Um, and I think that's important because if you can do that, you can get all the questions answered. And then after that, if there is a central place that people can email their questions into, be that a website or an email address, and everybody who applies, who showed up for the meeting, who pulled an application can get the same information at the same time. I think that would go a long way to ensuring a credible process. And one of the other things I saw in the application where it's talked about didn't want to hold the board accountable for certain errors that might have occurred in software or application dates or paying your fees. I would just say that in the case of, I had a question that we submitted on the 10th day and using 15 days as a submittal period and nothing got addressed. So if it took you 2 days to get back to the everybody, the mass public, with an answer, then I'm thinking that it would be righteous to extend the application date 2 days. Because I think it's more important to do it right than to end up as we have in the past, 2 application processes. And I know I've said this before, but I got to say it again. I work in a cellar and it's not easy. And if there's a simple way to submit your application, I highly suggest that that be considered. The questions that I'm going to dwell into, I'm going to sort of follow the NCRR with questions because, again, it's not for my benefit because I can't get one of these licenses. But I know there's a lot of people who call me and say, "Hey, how do I get into the game?" And they don't have lawyers. So I might be a little long-winded, but I want it for the record for everybody's sake. So 5.065 talks about the reduction of renewal fees. So, and consumption lounges, but any fees that are going to be reduced are only going to be reduced for social applicants, correct? Can independents apply for a reduction in their original fee and or renewal fee? And if there is no definition, and I don't think there is, for minimum scoring guideline, it refers back and forth throughout the document. So again, I just don't want somebody to be able to use that down the road to say, there was no minimum, so therefore, how could you score it? And even though you didn't score it, but that's my point. Number 3 is about posting the application. So for 5.020, it talks about A, B, and C. I would like to see each applicant or at each company that has a license, marijuana license, be able to receive a letter or email or something about the applications that are coming out. Whether they can apply or not, I think that would be in order. In number 2 of 5.020, it says the board will accept applications to request applications issued pursuant to this section for 10 days. I read through this and I did not see how long the application is going to be out. Prior, they were out for 45 days, whatever that date was. So if it's 45 days or 60 days, I think under the keeping the public aware when the applications come out, they should have how long they're going to be out. And then what days. And I think also if you are allowed to submit your application and it says 10 days here. But if you're able to submit your application at any time during the time that the application is open, that's going to stop you from doing like we talked last time, like California did, Los Angeles, and everything gets jammed up because there's too many applications trying to go through the pipe. So if there's a, that we can submit or they can submit their applications at any time, I think that'll help. Um, Okay, 5.040 talks about the application and electronic licensing. But again, it doesn't say what kind of system. Simpler, the better, I think. Because if not, we know you're going to have at the next meeting, folks showing up after that. Everybody submitted saying, I couldn't get my application in. So if they've got 10 or 20 days to submit their application, and if there's a simple process, that argument goes away. Here at the top, it says the board will grant no grace period for an application once the application period has been concluded. Will not be held responsible for technical or other issues that may occur with the applicant that may experience with any electronic license in the application system during the application period. So as I just stated, I think that might be one way to help mitigate that as an issue. The board cannot guarantee a response within a particular time frame or prior to the application submittal deadline. Okay, I agree. But again, if it takes 3 days or 5 days, extend it 3 days or 5 days. I think that's would be in everybody's best interest. So one additional question, it talks about here in section 5.040 in E, the address of the proposed cannabis establishment where it would be located. So my question there is this part after the award or before? So if we get the initial application, I know there's information you have to fill out, but to me, it's not clear if I'm gonna have to put the application where I want the location and which in the jurisdiction, as I understood last meeting or meetings, that it could be you just identified the government, city, county, North Las Vegas, or Henderson or wherever. And then if you were awarded, you would come with the more particulars with the dates. But that wasn't clear to me, so I wanted to point that out. So, and if that's the case afterwards, then the information that's required by the landlord, the property owner, is all copacetic to follow that. Okay, now I'm at G. So G talks about that if you have 2 days to respond, or no later than 2 days to respond. And I would just say that if in fact the applicant has provided a phone number, email address, cell number, or office, that I would hope, it doesn't say no, but it doesn't say yes, that we could try all 3 of the contacts just to ensure that contact was made and every effort that this body has. On I, it talks, and I'm not sure if this is the independent or social equity, but it basically says that you cannot be 5% or greater owner in an entity or organization or on an organizational chart and apply at another license. So my simple question is, so one person on one license, one person, if be that an LLC or however they got it, can only be on one application that's turned in. it's very clear on the following page that if they are, that they'll be removed. But I just want to make sure that that is for social equity and independent, or if not. Payments. Okay. 5.045. I'm going to make the assumption again that this all takes place after the award. Random number selector. Okay, we know that's afterwards. The diversity plan. So again, this one isn't clear, but I'm going to make the assumption that this is going to happen after the person has been selected and has moved on to the random number selected and been selected there. And if that is the case, I think that more people would give you a more competitive diversity plan if they had to produce that upfront before they got their license. As I think after the fact, it's not as important. So I would just ask that that be considered. Just a couple more. Still part of 5.045 and B1, 15B1. The applicant receives a letter that they have been selected. I would also want to believe that you also are going to post it on your website or somewhere else so that everyone knows around the same time. But it says evidence of a social equities applicant resident that is in an approved census tract displaying the original or certified copy of two of the following documents. So it goes back 5 years, but I thought originally, and I could be wrong, so that's why I'm gonna state it on the record, that it was for people who grew up in certain census tracts. So the person who may have just gotten out of prison, I think, has to be out 10 years. But I didn't see any of this. I'm not quite sure how the 5 years fits in. But if we're talking about folks who their family members, because they were locked up, that's going to far exceed the 5 years. But the two of these that you're requiring, I think you'd have a wider, deeper pool if you went back 10 years as opposed to 5. And number 2 in that same section talks about the social equity proof of conviction. I would think that they should have to provide that up front, even though there may be detail later. But I think as a part of the original application, they should have to provide that. And then I'm going to make second to my last comment. All right, it says in item C there, the board will determine on a case-by-case basis the relative weight to give, if any, to any criteria of merit considered and established by the board. If I recall, the law, the state law requires that all merit be presented upfront so that folks know what they're applying for. And I can just tell you that was in the last lawsuit, the merit was a big issue. So I just want to bring that to your attention. In 5.055 talks about this information, A through D, A through C is going to be added to the application. And again, I guess this information is going to come afterwards. To me, it would seem that you would want this information up front. Thank you very much and appreciate your time.
Hello, my name is Brian Harris. I'm the owner of Black Book Media. I actually had asked Frank to help me so that I could get or at least apply for a consumption allowance. One of the concerns, I want to go on record because one of my concerns, obviously, is many times the illusion of inclusion puts together processes that seem to be transparent and give opportunity. Systemic racism, a lot of times, is cloaked in the appearance of giving equal opportunity. We look at the first time and the amount of different licenses that went out. Frank is the only African American that was given a license. With the grandfathering of the existing dispensaries, and with the criteria put forth, my concern is, are you just running us through the same loops? And when you look out, the amount of African Americans, and I'm not talking diversity, will be low. We are the community that was hit the hardest with the fake war on drugs. But when it became legalized, we were the less of the communities that were actually included in the opportunity of the cannabis industry. So I ask that you go forward, that you do serious attentions to make sure the Black community, and again, I don't say diversity, I don't say inclusion, the Black community has a high percentage of utilization. And I've never been to jail. I shouldn't have to go to jail to get a license. So I hope that you make sure that this is really done and we don't find business as usual where 95% of the licenses go to people who don't look like me. Thank you.
Other speakers?
Good morning, members of the Cannabis Compliance Board, Director Klimas, Deputy Director Miles, and CCB staff. My name is Lake Martin, and I'm the Executive Director of the Nevada Cannabis Association. I want to first thank you for the tremendous amount of work you've done to get us to this place, and we appreciate that you've involved stakeholders at every step of the process. With respect to Regulation 5.040 subsection 1E, our concern is with the term final license to operate because the term final license is not used or defined in statute. And we would support Chair Douglas's recommendation to change the language to the date upon which the application was submitted to the board to match what is in 678B 250. Thank you.
Hello, good morning. My name is Brendan Bloom. I am the Vice President of Experiences for Green Thumb. I'd just like to thank you for this process. I've stood up here a few times and given feedback based on what our company and some of the industry has said. So I just want to thank you for that. I'm going to give a little background on what I do and then go into the one piece of regulation around the grandfathering that we currently have an issue with. So I've been with Green Thumb for about 7 years. We currently operate 8 stores in Nevada, some in the south, some in the north. We cultivate, we distribute and infuse products throughout the state. We opened the first cannabis consumption lounge east of the Mississippi in northern Illinois last year, and we have a lot of experience on how to get those stores open and then manage them in a safe, compliant manner. So that is where my perspective comes from and why I'm up here speaking today. The one recommendation that I have is under NCR 5.040 1E, should exempt from the 1,500 foot distance restriction all retail stores that are already existing and operating as adult use stores prior to the application period for consumption lounges. It has been previously established that distance requirements for consumption lounges should be the same as distance requirements for adult use retail facilities. AB 341 authorizes the board to issue consumption lounge licenses to adult use stores if the lounge is attached or immediately adjacent to the store and the adult use store was otherwise in compliance with the distance requirement at the time of receiving a license. Thank you.
Good morning, Scott Rutledge with Argentum Partners for the record. On behalf of the Chamber of Cannabis, we began this process, it was December of 2020 in conversations with then Chairman Yeager, who was sponsoring AB 341. And that process involved a lot of give and take. There were a lot of conversations. We've had meetings with staff about this. There were some licensees that wanted to see some things done a certain way. And we, as the chamber and working with the chief sponsor of the legislation, trying to ensure as much opportunity and equity for new entrants into the market while also allowing existing retail stores to have a chance to have one of these licenses. And through that discussion, through that debate, we heard proposals for, can we get one for each county we're in, or maybe give us two instead of one? And I sat in some, they weren't smoke-filled rooms, but a few of those rooms along the way, talking to folks and their attorneys. I will say that it may not have been stated in our comments prior, but I do want to give a tremendous amount of credit to Chairman Yeager for his work on this legislation. And going back through all the email traffic during the session and the conversations with all of the various parties. And I know that your staff, they were very involved through that process as well. We had a lot of conversations trying to understand what should we send to the CCB to sort out and what should we try to clarify in statute. I think ultimately a lot of this we wanted the board to determine in the end how to do some of these things because we felt like that made more sense. Feeling pretty good about this process until the last version came out, the section that's been referenced already, and wanted to echo the comments from NCA, Lake Martin, and Chairman Douglas's suggestion of this amendment of replacing that new section in 5.040 E Roman numeral 3. There's an arrow after that, so I don't know what exactly that section would be called, but where it starts with a cannabis sales facility applying for, and it mentions the term final license. As has been noted before in consultation with staff, final license does not exist in statute. That is not language that we supported. And the reason we don't support it is because if it leaves out any retail store that has an existing location approved by this board from being able to apply for a lounge license, that was not the agreement. That was not the discussion. It was not the intent of the bill sponsor of the legislature. And in fact, this morning when I read the comments from the Nevada Resort Association, and they supported that new language, and I thought, this is interesting because I'm going back to my emails on May 30th, I think, 31st, and there was a floor statement that was read into the record by Senator Chris Brooks, and the language that was used was suggested by the Nevada Resort Association. And I submitted it on their behalf to Senator Brooks, and it clearly states, AB 341 clarifies that retail and independent consumption lounges are subject to all distance separation requirements unless otherwise grandfathered as part of an adult use cannabis retail store. No mention at any time during those consultations by the NRA or anyone else for that matter of a date, November of 2019 or final licenses, this and that. So it's been a frustrating process because we made some commitments during that process on behalf of the chamber and working with a lot of different parties. And to see some people have selective amnesia around what was stated at the time, what was agreed to at the time, has been a little frustrating. So I do appreciate the work that you guys are doing. I do support Chairman Douglas's suggested change. I think it would clarify and bring us back to the agreements that were made during the process, what I understand legislative intent was during the process. And again, would hope that the board would consider that amendment. Thank you very much.
Stepped in front of Ms. Connor. I'm Aisha Goins, the Executive Director of Cannabis Equity and Inclusion Community, also the owner and president of Black Joy Consulting. And here today with me is Pathway to Ownership participants to witness this process. I appreciate the board, staff for all the hard work and the inclusion and the transparency of the regulations. I would be remiss if I didn't stand here on behalf of the Pathway to Ownership participants and say this isn't a true pathway to ownership. I am only invested in the social equity component because it's in the best interest of my community. I don't necessarily believe that this provides real ownership opportunities for those persons. The financial obstacles that have been put in place continue. It would seem that the Cannabis Compliance Board is very intentional about inclusion, yet the licensing and policy continues to block out a large amount of people. I know that that puts the onus on me and the legislators, but I wanted to state that for the record. I do have a couple of comments that I'd like to make regarding the regulations. 5020, Mr. Hawkins pointed out that there would be postings and there would be mailing, which I'm assuming this is alluding to a listserv. What I would suggest is that you add not just the internet, but also some point of social media. You're currently already posting on social media. I'm not sure why it was excluded in here, but I just want to make sure that it's added as a second point of activation to the community. I also want to point out one of my questions regarding an attestation that the applicant can has or will secure evidence when available that the applicant either owns a property or will put a property there. Later on, it goes to talk about in 5055, it talks again about having to secure a property. One of my concerns is, well, it talks more about jurisdictional securing. So one of my concerns is that an applicant will say they want to be a place. And I know it's the intent of the board. You have said openly that it's the intent of the board to not have to have applicants secure that location because of the lack of availability in zoning. But my concern is if that applicant states what jurisdiction that they're going to be in and then has to change that jurisdiction, that they will be penalized in the licensing process. So I just want to make sure that the language doesn't penalize persons for having to adjust their original idea of property, specifically for jurisdictions. So for example, because I know that my Pathway to Ownership participants is here, what I'm specifically speaking to is if you declare in an attestation that you're going to be in the city, that is the idea of where you want to go, that if you have to move to the county, you're not penalized for having to move to the county and then your license is in jeopardy. So I just want to make sure that that reflects that in language. And again, I thank you for your time. And Honorable Douglas, you know, when I see you, it just reminds me of all the work that is still ahead of me. So I appreciate your stance and your inspiration. Thank you.
Hi, good morning. Mitch Britton for the record. I'm the managing partner of the Thrive entities. Here to comment on these proposed regulations. I was personally heavily involved in the negotiations in the last legislative session. And I wanted to make sure that I put on record that these proposed regulations regarding the lounge grandfathering runs afoul of the agreements we came to during those negotiations. And as Scott mentioned earlier, I would encourage you to review the floor statement of Senator Chris Brooks and carefully review the June 22nd opinion of the Legislative Council Bureau regarding the legislative intent of AB 341. I would urge that the board thoughtfully consider all those that have come forward this morning. And I know that the industry wants nothing more than to maintain being the gold standard of cannabis regulation, but pushing these regulations through just to speed up the process rather than getting it right jeopardizes that notion.
Good morning, Chairman, members of the board. First, Amanda Connor with the law firm of Connor and Connor. I would like to thank the board and staff for all the time and effort that's been put in those regulations. I know I read a news article this morning that said 15 public workshops were held discussing these regulations. And I know that the board has said before, they want to get it right and they want to make sure it's a transparent and open process. I think, Ms. Goins and several commenters brought up some great things that need to be addressed, but some of them can't be changed at the regulatory level because it's in statute. But one thing I would say is specifically with regards to the grandfathering language, I'd encourage the board to just put in the language that's required by statute and not create additional criteria. The use of final license creates an additional criteria that was not in statute. And to highlight an example, it could affect over 60 licenses of dispensaries in the state. The reason why, if you look at the medical program, in the medical program, you had to obtain land use before you applied for the medical license in 2014. And then you didn't build out and get the facility approved, sometimes for several years. And if you use that final license, they referred back to land use in 2014 that was obtained. And for 2 years, protected uses could have moved in. That's problematic. I don't think that was the intent of the legislature, nor is it the language in the statute. I would encourage the board to use what language was adopted by the legislature, much like Chairman Douglas suggested this morning. Thank you.
Hello, my name is Denise Parker. I talked to y'all last time, but I'm gonna talk to y'all again because I got some issues. Y'all, I'm not gonna disrespect y'all, but y'all kind of like an older sibling that kind of like get on y'all younger siblings' nerve because y'all not, listening. Kind of, it's some stuff that needs to be done. Feel me? Like, for instance, the whole social equity thing. So I'm 23 years old. I've lived here my whole life. I went to Andre Agassi. I went to Imagination Plus. Imagination Plus is on MLK and Alta, but they changed it and they changed it to something else. And basically they changed it to something else because my grandma passed away there, basically. And once she passed away, because she worked there for a very long time till she was about like 80. So she passed away at work. Once she passed away, they closed it down. I went to Joe Mackey. That's on Duke and Ingolstadt. And I lived over there with my grandma on Kings Avenue. And I live on the north side, but when you look at my thing, I'm literally right off the border, with my projectile or whatever the case may be. So it's kind of put me in a situation because I lived on the west side for a long time. And also I don't remember what statutory law it was in, but you said it's child, parent, and sibling. Y'all, I know y'all good and well, y'all did a family tree. I know y'all have. Where about the grandma? Without a grandma, there wouldn't be no y'all. It wouldn't be no you. So how you just gonna exclude her like that? Cousins too, aunties, uncles. Y'all know that parents is not the only one that raise a child. It takes a village to do it. So why is y'all excluding the people that actually help? That's wrong. So y'all should actually add that in there. Put grandmas and cousins, because we have first cousins, we have second cousins that may have been affected, and that's just wrong that y'all kind of excluding them out. And I don't like that. Because that's kind of putting me in a position where I did live with my grandma. You basically just saying I'm not social equity and I have to be independent. Now I got to cough out all this money and try to write financial stuff and hardships. I agree with Frank, what they said, because it just don't make no sense. And also the limitations. People want to do spas and stuff and the topicals. Basically, y'all trying to say it's the milligrams, but y'all need to look at the terps. The terps is what gets you high. Okay, the myrcene, the limonene, that's what we need to be looking at. It's not really the milligrammage per se. That has an effect to it, but we also need to look at the terps because that's what's going to what affects you. Because that's like affecting the spa, saying that what they can only have like 100 milligrams in like their topicals and stuff. But if you're educating and we have the training to do it, and we want to educate and say, oh, it's overconsumption, people should already know that. The employees should know that once that person has had so many sessions or whatever the case may be, maybe just don't come back, or have a tracking system for a customer that says, oh, you've done this so far. Maybe we'll just use like a different lotion. Have that, the option of the non-infused and the infused option. If you do want to come back and get a massage after so many times of using the CBD or the THC, maybe you just won't get that again. Just have something else, but you're kind of limiting them and not trying to give them like options. And basically, once you have the training, you're going to prevent overconsumption. And another thing is, once you say you have CBD required and offered, and water too, and that's known to bring you back down from your high is the CBD. So as long as we have that and we're educating to say, hey, like you don't, that people get the thing misconcepted that, oh, we just smoking to get high. You don't have to smoke to get high. You can smoke just to feel good, because this has medical benefits to it already. You could just microdose. That's where people get it wrong. You need to microdose. And that's why you need to educate the customer, say, hey, have you indulged in this before? They might say yes, they might say no. Ask them what their experience is, because my tolerance is very, very high. I'm not gonna lie to you. I'll go to a dispensary right now and cough down 2 chocolate bars and not feel anything. I'm gonna keep it hot. And y'all see how little I am. So like my tolerance is pretty, everybody knows their tolerance is what I'm saying. Ain't nobody walking around here with no full. They like, just like alcohol. They know they limit. You know you can knock down 2 bottles of no freaking Casamigos, so don't do it. That's like smoking. You need to pace yourself. And you also have to think about the time that they're staying there. It depends on like what the business is. You feel me? So like saying that, oh, you can only get like 1 gram. What if I want to come back and smoke again? Maybe y'all just need to look at the THC percentage and the myrcene and be like, okay, well maybe we could just up like and give them an ACE or whatever the case may be, as long as it's below a certain percentage, or the myrcene or the limonene or whatever the terps is that gets you like the most high. You need to like be looking at all of that stuff too. Everybody's just looking on the surface. You have to dig down deeper and look at research. Okay, that's what we're not doing, especially with cannabis, because it's new. Nobody really knows anything. We kind of just playing it off ear. But the more research that we do and trying to figure stuff out, it's going to be easier. And I like to say that because I went to UNLV and I like to do a whole bunch of research. So that's what I'm just saying. And also, I want to be able to make my own products, but you're not offering the production license attached onto it. Okay, so what I'm saying is maybe you could have a lab person come in there, like when I make my butter or my sugar, because now I'm just feeling like it's still the war on drugs and I'm being excluded to be able to like with my creativity and my limits, because I know how to do all those things. And I'm pretty sure a whole bunch of other people know how to infuse some sugar and some butter and all types of stuff. But y'all want us to go to a dispensary to get it tested when I know y'all got the resource to give us at least like a lab agent. I've seen in all them laws, y'all want to agent this, agent that. We're going to give you an agent for this. I know y'all can give us an agent for a lab to come at least like a couple times a week to test our stuff. You have to buy it in bulk, maybe from a cultivation instead of a dispensary or a retail, because that's just putting more money in their pocket and making it hard for us to get off the ground for somebody that's never even done this before and trying to get into the game. I ain't got no money. I got 2 cents in my bank account. Okay. So I don't have any money. So y'all need to put that in consideration, that a whole bunch of people that want to get in this game, they like me with $2.02 in their fucking bank account. So something needs to give, y'all, for real. So y'all can figure out some things that y'all could do. And also another thing is, I work at DGF, Green Thumb Industries, right? So I work in flour. I've seen so much hemp and stuff get thrown away, y'all. And I've looked up research and stuff that we could do to actually something that's useful, because y'all deeming it as biohazard, But their ships have been made out of hemp, houses, clothes have been made out of hemp. Y'all could do so much with it, and we just throwing it away and tossing it. The homeless could have clothes right now, and they don't have to be living on the street with nothing. You feel me? There's stuff we could do, but y'all don't want to look into it. But if y'all want to look into it, I'm your girl for it. I'm not lying, y'all. For real, I like to do research. I'm trying to get UNLV on my side right now because I want to have a hemp committee. So don't think I'm finna just be the only one here talking about him, because I'm going to have a committee from my job that comes here and talk to y'all to back me up, because it's power in number. And to get what you want, you got to keep bugging and bugging and bugging and being persistent. So best believe y'all gonna keep seeing my face, and I'm gonna keep saying the same thing and bringing my people behind me. So that's all I gotta say, guys. Have a good rest of your day.
Thank you.
Hello, I'm Eric Cannabis, a member of the CEIC. I'm a student of the Pathway to Success program. I have a few issues as well. Some of them are the same as what she just spoke about. In 6.080 subsection 3, cannabis consumption lounge may only acquire single-use cannabis products, cannabis and adult-use cannabis products needed for ready-to-consume cannabis products from a cannabis sales facility.
Let me stop you there. You're into the next half. If you have comments about the first half, we'll take it right now. If not, the other, you have to wait until we get to the second part.
Okay, that's not included in here?
We're just talking about the application process right now. That you're talking about the operational one, which we'll talk about in as soon as everybody's done giving
Okay,
comments
I
on the
have
application process.
something to say about the application process as well. Sorry about that.
Good.
Okay, so the fact about the family, immediate family, and not being able to have it extended to your grandparents as well. You know, a lot of people are raised by their grandparents, and that not being in there disqualifies them from the social equity qualification. To me, that doesn't make any sense. And I'll just wait for the rest to tell you what else I have to say. Thank you.
I was wondering if you were stretching, or if you were coming up.
Thank you, Mr. Chairman. John Ossegara for the record. Yeah, I don't know, following Ms. Parker, that'll be hard to beat. Mr. Chairman, today I'm here on behalf of clients at GTI, Curaleaf, and Thrive. I think what I heard you say earlier, your suggestion that the language mimic 678 B250, that probably would be something that my clients would be supportive of. And, you know, I guess I would just ask, is that, what you're intending to do? But if, without having a back and forth, I certainly would like to give you my thoughts on the legislative intent. I certainly don't know the things Ms. Parker knows, but I do know the legislature. And so I think I can offer some thoughts there. During the 2021 legislative session, the Nevada legislature passed Assembly Bill 341, which which outlined a robust framework for the licensing and operation of cannabis consumption lounges. AB 341 created two types of cannabis consumption lounges. One, the independent cannabis consumption lounge, and two, the retail cannabis consumption lounge. Both lounge types were considered adult use cannabis establishments and would be governed by the same licensing protocol. AB 341 included certain distance requirements for the licensing of retail lounges. However, certain retail lounges would be exempt from the distance requirement if the retail establishment to which it would be attached or immediately adjacent was in compliance with such distance requirements at the time the retail establishment was issued an adult use cannabis establishment license. An adult use cannabis establishment license is defined as a license that is issued by the Cannabis Compliance Board pursuant to 678 B250 to authorize the operation of an adult use cannabis establishment. Neither NRS or NCCR refer to final license. One mainstay of statutory interpretation is that where different words are used in different parts of the statute, the words are presumed to have different meanings. This canon militates towards the grandfathering provision extending the proposed retail lounges. Of note, in NRS 678B 322 2A, explicitly references the time when the retail store was issued its license. In contrast, NRS 678B 322(1)B explicitly references the time when a parent retail store becomes operational. So what happened is all AB 341, in my opinion, exempted all cannabis sales facilities that were operational as of the date it submitted an application for a retail consumption lounge, regardless of the date that it received final approval from the regulatory agent to begin its sales facility operations. The proposed language is problematic because the final license is not defined term in NRS or NCCR, and it goes against the language and legislative intent of AB 341. Moreover, the use of the term final license creates unnecessary confusion and unpredictability for several of the industry's cannabis sales facilities. It's currently unknown whether protected uses had moved in after the date, like Ms. Connor stated, after the date the land use approval, but prior to the date of the final license, which in some cases could have been years. So in summary, Mr. Chairman, the word and the use of the term final license opens the door for litigation, creates unnecessary confusion, and creates a substantial and unforeseeable risk to the operators within the industry. And I would hope that you would consider fixing that part of the regulation. Thank you, Mr. Chairman.
Thank you. Do we have another speaker in Las Vegas? Yes, sir.
Good morning, Mr. Chair and members of the board. Excuse me. My name is Tim Ellie. I'm here representing Chemovar.io. That's my startup. And my reason for making the public comment is based on the lack of opportunity within the cannabis industry. We have in the state of Nevada, if not at the very least, second to last in scoring for opportunity and diversity within the executive roles of this industry. This is a number that we have to take serious. The reason is some of the greatest minds in this industry that pioneer this industry and literally pioneer when we took signatures and we had to basically collect signatures and have these signatures on the ballot. There are a lot of faces that I do not recognize here when we had to basically make those pioneering efforts, and when we had to jumpstart the industry, we had to write SOPs. We had to come up with basically procedures in which this industry could operate. We literally came out of our intuition. Everything that you see in these dispensaries, all these products, they came out of our intuition. We wrote these, we make these products. These products were not included when we initially amended NRS 453A was passed. We as medical cannabis patients had literally had to basically come out of our own ways of supplying our own medicine, and we had to learn. My experience in this industry is from a patient perspective. I grew up from to being a grower and to being a cannabis breeder as well. The limitation of the consumption lounge to the people of that pretty much were marginalized from this industry is really upsetting. I hold right here in my hand a result. This was results from 2016 tested by DigiPath Labs. And I have a very serious challenge for the industry as we speak right now. I'm going to challenge for the lack of opportunity that for those that have this opportunity, if anyone could imitate any of this innovations that we have basically started before we were before we were taken out of this industry. In other words, you're looking at a landrace cultivar in which the industry does not have. You cannot walk into any dispensary right now and ask for a pure landrace sativa cultivar in which they would have it available. Anything that we know about sativas are basically polyhybrids that has been crossed. It's been specific of interest for some of us to work within that area. I have worked within a cannabis dispensary as well. Within the labs, I have experience. I have seen um, the most the most important part of the industry that has to do with genetics, right? That has because that's literally the backbone of this industry. We're failing. We cannot have cultivators that are very consistent in basically producing cultivars that are disease or pest, not pest infested. Literally have to go through the process of quarantine, just to radiate all these pathogens, just so we could be able to have it on the shelves for sale. In other words, I'm appealing to the board, and it's not going to be my last time. I've been appealing to the board since 2013 for an opportunity to be able to basically exercise what we're good at. I would like for the board to take serious that um, the other foundations organizations, which has to do with inclusions, really has left some of the vital community members within this industry have left us out of the conversation. It is literally a back door handout, just like we have experience within when the Department of Taxation was in control. All the numbers of corruption, it's right here, right in our face, and it's blatant. There's about time we do something about this. And the only way to correct the wrong is to open up the opportunities to those that could really help innovate this industry. We're literally standing at the backbone of this industry. We have proponents that have financial. We understand the importance of the finance to move this industry forward. As much as finance is important, we also need innovation to basically keep this industry afloat. Also, one day we're just going to stand here and have pretty much nothing to discuss. So I'm here and I'm sorry, but I'm appealing to the board once again to take into consideration the importance of including those that were marginalized. And what I mean by including specifically, it's not a pathway to white labeling. What the industry is currently doing is giving us a pathway to white labeling. White labeling is not the answer. What we need is a pathway to licensing. We have the minds, we have everything that it takes to be able to compete. All the stores such as cookies that is competing toe to toe with all the big brands. It all came from the legacy market. Without the legacy market, and that's one thing that the state of Nevada has done pretty well is to basically keep out the legacy market. That's the reason why we have all these MSOs from other states taking ownership in our industry that we helped establish. And the reason is this same opportunities that is granted for other states is not granted for us here. And I would like to make that appeal. Thanks for your time.
Thank you. Anyone else in Las Vegas wish to come forward? If not, we will go to Carson City. Anyone in Carson City? Let's do this first. Period. It would appear we have no schools in Carson City. We're kind of at a catch-22. We've taken public comment. Normally, we do not comment as to comment, but we've taken it to hear that and help us to wade through what is before us today. But this is a procedure in which we are attempting to adopt regulations. I think it's appropriate that at least if there are comments that cannabis, just to make reference what's here and any pertinent comments that you are concerned. So state, so the board members can hear that before we get into discussion.
Sure, thanks, Chair. I just have a couple things on this first section. These are two small clerical edits that I think the board or we'd like or suggest or support the board to consider when they adopt. And it is just two references that that are incorrect or need to be changed. One is on in regulation 5.040 sub 1 sub K. There,
Repeat that section.
yes, 5.040. As I also get to it here. Sub 1 and sub K of that. It has a reference to section 2A10I in that, and we need to remove the reference to section 2A10I. I think that section is just gone as a matter of some of the iterations and edits that we've done. So that is simply just to clean that up.
It's actually 5.045.
Can you clarify?
So yeah, it's not to be removed completely. It should be shifted to 5.045 to A10I. And my apologies, it wouldn't be 2 A10I. It would be on this one. It would be changed to 1 A10I and 5.045. And the reason that happened is because these were all combined into one statute at one point. We broke them apart. We just missed a couple of the.
Deputy
References.
Miles, it is actually 2.
Is it actually 2?
Yes.
All right, then subsection 2. Oh yeah, there it is.
So you're keeping that there with the nomenclature change, or you're moving that to another locale?
We're keeping it exactly the same. We just add 5.045 in front of it.
So then for my second one, I have no confidence that I'm going to get this one right. Deputy Balducci and Deputy Miles, you can help me. There's a second one, correct? That references 280. That needs to be corrected. Is that right?
That's correct.
Where is that?
It's under NCCR 5.045. Subsection 2. 10. 2A10.
That discusses the diversity plan, correct?
That's correct.
And it just needs to remove in the third sentence when it references 678B 281F, just remove the 281F. Is that right?
No, actually, it should be removed, but also just corrected to the correct statute, which
Got it.
is, let me pull it up. Which is 678B.324 4A1.
So outside of the grandfathering issue, those are the only two other clarifications that I believe we have, unless there's any that I missed on at least the first portion.
Executive Director Clemens, there is under NCCR 5.040 again. It's actually right above the section we just corrected? It would be the same correction. It references subsection 2 when that was moved down to 5.045.
Okay, so that needs to be removed. Great. And that's all I have.
As I indicated previously, I had a concern as to language. After 5040. Subsection 1E. And I guess the question I have is whether that would be considered a substantive change or illegal. If that's made, would need to be pulled out and made separately because of notice requirements. Well, that is something in light of statutory, it would not be substantive. So that's kind of the question. So that we would have to, if we make that change, pull it from what's being offered today and bring it back up and say a special meeting next month.
For the record, Senior Deputy Attorney General Ashley Balducci. I believe Ashish Bala is also on the line, but I believe we have recommended that if you are going to change it, that you just hold it back and then we'll renotice it. So that way there is no issue as to notice or argument as to whether it's substantive or not.
I asked a question, been changed to this so that the other board members are aware if they consider that or not, since the time for the board to weigh in terms of if they have other concerns in this first area.
Chairman, which section was that?
This was as to under 5040, and if you go to
21 after the arrow.
Okay, thank you.
what I referenced as to language.
Can I ask a question of the proponents of changing that matter? So when it does come back, we have a little more information? Or is that not procedurally a good, what I should be doing?
She wants to ask them a question. We've heard from proponents at this point. What we have. I really don't want to open it up any broader than need be at this point. Kind of understand the lay of the land, and I'm not sure even with that it's going to totally clarify, but I think it goes to statutes as adopted and the verbiage that we have in the NRS at this time. That's the attempt to clarify. Just for the record, going outside of what you're asking, I am not as comfortable with LCD's opinion in light of reading through materials. I additionally am not as comfortable with some of the positions taken as to what was agreed to. The agreement is not between the parties. The agreement is by the legislature on the damn record. And to take this down to just a backroom deal is not what we want, but that's what we have. We are saddled with making sure everything is open meeting law and out in the public. We can't even have side discussions with our full board unless it's open to the public. The legislature is allowed to have any discussion they want to have. There are issues and there are problems with minority set aside and what they did and what they didn't do. And there are problems with what was done the first time, and we are attempting not to do the same thing that our predecessor was accused of doing in terms of the first licensing. We are making sure that as this body speaks, it speaks with one voice on a record, not to individuals to give them a leg up. We are attempting to say that if you fill out the application as prescribed, you will be qualified at least to go into the drawing round, opposed to you get weighted and you weighted in, weighted out based upon those side discussions. That's the allegation. And so you were eliminated. There's a lot of concerns and lessons that we are attempting to incorporate from around the country as they are licensing. But one of the things around the country that has seemed to continue is the social equity issues and the folks who are in fact left out, be they poor white, be they black, be they Asian, being the Latino. There is not really a social equity. We have tried to learn from some of our neighboring jurisdictions. However, what we do or don't do should be, as someone pointed out, based upon what the legislature in fact adopted. I have problems with what their intent was. I've seen different things in there about intent or lack of intent that makes me query and wonder about what they really wanted to do. But having said that, this is what we have today, and trying to produce a product that we can go forward with and not have people omitted in error. So I guess one of the questions I have, and still come fully around to your question, back to our staff. Mr. Hawkins asked a question about filling out applications and how fully an application has to be filled out to be seen as a completed application versus an application that is parsed out later after somebody goes through drawing round. Just for clarification for the record, what our intent should be, as you see.
Absolutely. Again, the application is going to be on the Acela system, and it's going to be electronic application, and it's going to be mostly attestations. You just check the box, yes or no. The only thing you're really going to be filling out in the entire thing is the owners list of owners, officers, board members, again, which is statutorily required. You're also going to be including a preliminary diversity plan in the initial application. Those are really the only two things that you're filling out besides check boxes. What was one of the other? Oh, you were talking about if people are having problems and have questions. Statutorily, we are limited to a 10-day open period by statute. So there's no way we can just stop it and while other people are filling out and just extend it out 3 days. We're stuck with the 10 days. So what you were asking is, was there anything else specifically, Frank? No, just just say it real quick.
The other one was, so the 10 days is whatever you decide, but if you open it, are you saying the open period can only be 10 days long? Or
The application period where you're actually filling out the application to be submitted to the CCB is a 10-day period. We will be opening up and letting everybody know 30 days before that we're going to have this 10-day period. You'll be able to see the application. We're going to have question answer sessions. We're going to put out some videos on how to fill it out. I believe Aisha Goins is also helping people with filling out the applications. It is going to be a very, very straightforward, open process. And again, this application is going to be fairly simple, but the problem with it being fairly simple, I want to point this out, is you're attesting to certain things in this application. So please make sure these things you're attesting to are correct. Because if they're not, that will be held against you in the suitability analysis of the licensing process, right? And the big part of that, again, probably is for the social equity applicants to make sure you're attesting to your location and either your arrest record or your immediate family's arrest record, one of those two things. Just make sure you have that information before you click on the attestation. And again, along with everything else, I believe another thing you talked about was address. And I believe Ms. Goins also talked about the address and the application process. We limited the definition to, again, address is a required portion of the application process by statute. So, but we changed the definition of address to just local jurisdiction. So all you have to do is put in the local jurisdiction in the application. The problem with that, again, is once that is submitted based on statute, you're locked into that local jurisdiction. You cannot, therefore, a month later decide I want to do another local jurisdiction. I'm having problems with this one. I want to change. By statute, you won't be able to do that. You're stuck in that local jurisdiction that you're limited. So be very careful when you pick your local jurisdiction. Anything else?
While you were pondering, come back to Board Member Durrett's initial question. Without getting into a query as to intent, if you want to phrase a question, because intent is something that is codified in a record before the legislature. And so some of the statements about intent were not codified before the legislative committee on adoption. That's my only concern.
Got it. I don't think I will proceed. I think that that they would be pertaining to intent. And I get what you're saying about those needing to be on the record.
And I would like to point out too is, again, we will have question and answer sessions. I think another thing that Mr. Hawkins brought up was when you do have questions and you want to submit them, you check on the website, there is a specific email address, and it's also in the regs, that you need to submit all questions to. We're going to post those questions, that email, up on the website, and we're also going to answer that question and the frequently asked questions, so everybody has access to these answers.
Just Chair Douglas, for the record, just one of my difficulties in licensing some terms of art that are used that the legislature adopted don't reflect what is done in the licensing process of any licensing agency in the state. For most business licenses, you make application and you are an applicant. And then you have to meet certain requirements. And that's where that term final licensing comes up. You don't get a license the first day you walk in. Because we don't want to get in the California situation. You have to have a location which you're paying rent on when you make an application. Things of that nature. So the terms of art that the legislature is using and the terms of art that are used by a licensing agency are different animals. And I say that because early on in my life, I spent time as an attorney for a licensing agency. And we looked at that. And sometimes people came in, they made application, and they had to redo or undo or change because of zoning or health or whatever. And so they did not have a license when they first filled out their application. They were attempting to secure a license. But our legislature adopted certain words. We have to comply to those words within a certain reason. I also understand they don't totally understand, but they make the rules we have to follow. So that's, we're under my side on this one. But anyway, having said that, our board, where are they at in terms of being in accord with what's been put before them, or something they want to pull, or changes they might want to see, if there are concerns or whatever. This is the only time we can, as a whole, talk about what's there, what we want to do, if other members want to weigh in.
This is Member Nylander. we're getting conflicting opinions from everyone really on this issue. So I do agree with your original suggestion that we just go back on the grandfathering issue to what the language in the statute is, and just, go with that, because we have opinions, internally and externally that all differ. And these are legal opinions, they're opinions that no one agrees what the law really said. So we're stuck with that, as you said. And I guess we just go with the statutory language that, we have. And that should be duplicated, I think, in the regulation. That's sort of where I'm heading, but I'm just trying to open up the discussion.
Thank you for that.
Chair, just so I understand, that provision though, the hot ticket item, that would need to be pulled and renoticed anyway.
That's correct.
Thanks. Then I'll add for discussion the suggestions that were made today. I think many of them made by Mr. Hawkins can be accommodated going forward. I think anything other than that, any of them that were proposed today are just, we're not going to be able to pull these regs, or I don't speak on behalf of everybody. I would not be in favor of pulling the regs for those changes, given the amount of time we've had, and we're not going to be able to continue to keep putting these on agendas and then wait for more ideas and more ideas when I think so much work was put into these and most requests were accommodated. The vast majority of requests were accommodated. And I think that everyone has, of course, done a lot of work, a great job. And I think that Mr. Hawkins' concerns, most of them can still be addressed. For example, with the transparency, with publishing people's questions, publishing names of the people that were awarded licenses, stuff like that. Thank you. And again, my understanding is that we're not going forward on the 5.040 issue today. Thanks.
That's up to our board. I said my position was, it wasn't speaking for everybody. That was just, I threw that out there. Because we haven't got to the motion stage until I hear what the rest of the board members wish to say, what their input is. Member Merritt or Mr. Young, Dr. Young, either one of you wish to weigh in, or?
No, I don't. Thank you.
My only comment would be that I support changing the language in 5040 in regards to the statute. I certainly understand the wording for the final licensure, but to be consistent with the statute, I understand why we likely need to change that.
Unless another board member wishes to weigh in on anything else that's in this first section on application regulations, if we can possibly then have a motion for adoption of the sections 1 and 5, with the exclusion of the portion of 5.040 E at this time. I'll refer back to our legal and say the appropriate way to do it. Just excluding that E section, E1 section.
I would recommend just doing it from the arrow to the end. Delete that section. That was the section that was added in later. That can be deleted.
And I ask if legal is comfortable.
Chair Douglas, for the record, Ashley Balducci. That's fine. You can do it
I mean, you could pass E1, I through 3 and just like Deputy Director Miles said, the arrow portion, you can just strike that part.
I'm just hesitant to leave the language in play if we don't have that additional explanation there. That's what my concern was, why I was.
If you would like, we can withhold E and just renotice E, but I don't believe that's necessary because I think the part that's at issue is the arrow part and not anything above it.
That's a question for, make sure the board members are comfortable with what I at least recommended. We don't have a motion on the floor, but making sure that your questions are answered as to what we were about to do. So at this point, we need a motion to go forward with either as it is written or taking out one portion.
And Chair, and the inclusion of those 3 minor corrections that we mentioned as well.
Correct. Thank you.
So I would go ahead and move for approval with the corrections we've discussed on 5.040 and 5.045, which are just clarifications. And then the deletion of the language from the arrow down to the bottom, which I'm not sure that's the most articulate way to say it, but I think that's what we've been discussing. So.
Not to put a pun in, but that seems to be our intent. With that, do we have a second to that motion?
This is Member Young, I second that.
A motion, and we have a second. Any additional discussion by board members? Hearing none. All in favor of the motion as to those articulated changes and the one deletion, please say aye.
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 Any opposed? Any abstentions? Section 1, A and B pass at this time. That moves us to consumption on regulation, C, B, E, and F, G, and H. I, J, K, yes, thank you.
I'll repeat what I had earlier. Again, this portion is the operational consumption lounge regs, which are comprised of changes to regs 1, 4, 5, 6, 9, 10, 11, 12, 13, and the addition of the new regulation 15. The operational consumption lounge regs cover all aspects of operation to include sales limits, security, notice warnings, signage and label requirements, cleanliness, inventory, ventilation requirements, location requirements, and plans to prevent driving under the influence. And the main changes since the last workshop to the operational consumption lounge regs were, we updated reg 1.22. We updated the single-use cannabis product definition to include larger products. However, these products must include a warning for the inexperienced consumer at the time of sale. Reg 15.040, there was a clarification on who has to obtain the food handler card. And Reg 15.100, it updated the definition of immediately adjacent. We'll open the forum to public comments. Does any member of the board have any questions as to these regulations?
Not at this time. If we have public comment as to any of these regulations, second portion, consumption on regulations, we are open to entertain those comments. Now we get to your portion.
Thank you. I'm Eric Ambis, a CEIC member, student of the Pathway to Success program. So 6.080 subsection 3, where the cannabis consumption lounge may only require single-use cannabis products, cannabis and adult-use cannabis products needed for ready-to-consume cannabis products from a cannabis sales facility. I feel that it's not going to be helpful in the success of the cannabis lounge and the profitability. I For me, it just makes sense that we'd be able to purchase the products directly from the cultivation or production facilities so that we would be profitable and successful at the lounge. Um, another issue that I have is, and I'm appreciative for the 3.5 flour as opposed to the 1 gram that it was at, and putting in the caution for the potency and stuff like that. I'm in agreement with that. One thing that I would like to see raised is the 10 milligrams for the edible. I just feel like it is still very minimal. I know there is we could do the caution and, if there's more than 10 milligrams in that, but I would just like to see that raised. And yeah, those are the two issues that I have there. Thank you.
Thank you. Anyone else wish to speak to our regulation section? Ms. Scott.
Good afternoon. We've made it to afternoon, Chairman and members of the board. Amanda Connor, on behalf of Connor and Connor, I have just a few clarifications that I wanted to put on the record. Also, I wanted to make clear that although the purpose of the stated in the notice was only regarding to regulations for consumption lounges, in these proposed changes, there are several regulations that would apply to all cannabis facilities. And I'm not sure, in talking to some licensees that are currently operating, they understood that they would be impacted. So I think that's important to note. But some clarifications, specifically first with regards to 1.197 and 1.222 with ready to consume or single use, specifically with ready to consume edibles. I don't see any variance language noted, whereas normally with edible products, variance of plus or minus 15% is permitted for the milligrams of THC. So that was one clarification I was seeking. Next, with regards to 6.085 with the security, which is one of those that would apply to all cannabis facilities, subsection 3.3 references that you put it in the Acela portal in the beginning part or in that, but then in section 3.4, it says in the board's electronic licensing system. I believe there was an attempt to remove the specific reference to Acela throughout the regs in case the board changed to a different electronic licensing system, and I think that one was missed. So just wanted to point that out. With regards to 12.040 and 12.045, the labeling provisions, I think that with this, there's going to be some confusion because 12.040 says that all ready to consume cannabis and single-use cannabis products must be labeled with this label. But then if you go to 12.045, it says ready to consume and single-use cannabis products must be labeled with this label. I think the intent was if it's usable flour and a single use, then it's one, and if it's a different type of product, but there's no distinction. So I didn't know if they're supposed to get both labels because that's how the regulations read, or if it is dependent on the type of product. Then lastly, with section 15.015, which is proposed, it talks about that the cannabis consumption lounge shall verify the age using a government or a board approved scanner. That regulation language also appears for retail stores. However, the CCB issued guidance yesterday indicating that if the scanner is not working, they could outline a new process. While the regulations have not been changed to outline that process, and it still says shall. It appears that the board is allowing establishments to waive that regulation requirement. I would suggest, since we are here to adopt new language, that shall language either be modified or that the process that was outlined yesterday in guidance be included in the regulations. Thank you very much.
Thank you, Chair. Lake Martin, on behalf of the Nevada Cannabis Association, referring to 1.222 sub 5, because the Nevada Department of Agriculture has adopted changes to NRS 581 in SB 404 and is currently promulgating regs specific to cannabis weighing devices. I reached out to them to see if the language in NCCR 1.222 should be revised to reflect the language that the Ag Department is using in their regulations. This is referring to commercial devices. They're changing their definitions lately. So they suggested removing the term dispensing devices because that term isn't in NRS 581, and to replace commercial devices with cannabis weighing and measuring equipment. Again, just bringing the language of the two together. With respect to NCCR 6.085, I want to address the requirement to put information necessary to remotely access all cannabis establishments' camera footage in real time by the board or law enforcement agencies. So previously, this access was required to be provided upon request. And this requirement, the law enforcement have the ability to access all cameras in real time exceeds even what's required for gaming licensees. The requirement should remain that access must be granted upon request, and the licensee should at least be notified when the board or law enforcement intends to access cameras. Additionally, in 6.085 sub 3, it includes a new requirement that in lounges, security personnel be required to continually monitor real-time security camera footage. The term continually here should be clarified either here or in guidance in order to aid in compliance. In the gaming regulations, they do specify whether the surveillance room must be attended by a person at all times, what breaks are allowed, just more specificity regarding how continually the camera footage has to be monitored. In the case of lounges, these properties are a lot smaller than a gaming floor. In most cases, that's their expectation. They're going to be about the size of a bar or restaurant. And so we'd urge the board to not require a security officer be pulled off the floor where they can visually monitor customers and sales and put into a room to continually monitor security footage. So we would just seek some clarification now rather than later on those. Thank you.
Thank you.
Thank you, Mr. Chairman. John Osagira on behalf of Thrive, GTI, and Cura. I just mirror the comments by Ms. Martin and Ms. Connor on 6.085. Just seeking some clarification on those regulations. You think that they would add expense to the operation and for the licensee, and if we could clarify exactly what was meant by those regulations, I think that would be helpful.
Thank you. Other speakers? No additional speakers in Las Vegas. Do we have speakers in Carson City? City at this time? Concerns or clarifications or issues by the board? Our discussion before we go forward with this section.
Chairman Douglas, this is the court reporter. Can you please speak up?
Right, I was referring back to the board since we had no speakers in Carson City. Additional Las Vegas at this time.
I have a question.
Okay, thank you.
What is the citation for the mandate to have video cameras be accessed remotely by law enforcement? So I might need Ms. Martin to provide that.
Talking where it's at in the NCCR?
Yeah.
6.085, 1C3. Sorry.
So, okay, that's what I thought it was, but I don't see it. It just says the information necessary to remotely access it. So it doesn't change Metro's ability to access it in any way, right? Or the requirement to allow them to access it.
It's just putting the information in a cella, so we could use it if we needed to. That's all it is.
Yeah. Okay. So there's no additional mandate about Metro, about law enforcement or the CCB watching the facilities or being able to remotely access their cameras. Okay. Thanks.
And Chair, to answer your question, we don't have any corrections in this section from staff.
The concern was raised as to how to the purchase of product. That's something that is required by statute in the legislature. Good intent, bad intent, doesn't matter. The legislature requires that, so we can't go around that. That's something that has to be brought up at the next legislative session. So we don't have leeway on that. Sorry to say. I am a little concerned in terms of the security requirement as was voiced in the facilities for whether or not security would have to be monitoring the whole time. So I have a little unreadiness as an issue this time, but I don't know where the rest of the board is in terms of what's there, if they're comfortable with it or not. So I'd like to hear what anyone else has to say as to that particular requirement. And specifically, my concern was someone monitoring a screen while we have security in the room with the participants at the same time. So that's the question.
Chairman, I agree. Nothing is coming to mind as to how to change it, which I think we would want to do on the spot instead of holding it up. So I would be supportive of a change. I think I've heard, and I don't have evidence of it right now, but it's ineffective to be continuously watching the same video feed, and it's more effective to spot check that feed.
I don't know about ineffective, but I know I've been in some state-of-the-art gaming monitoring facilities. And they do catch everything. But having said that, the interrelation in these small facilities of someone on the floor or someone in the room monitoring, that's licensees. Potential licensees are saying it does add to cost of running their facility. So it's just something that my rating is on that total thing.
And Chair, I mean, obviously, this is something that we can issue policy guidance on, and as with all of these, we some of these things we don't know what we don't know yet with consumption lounges. Obviously, security, making sure people aren't taking product out of these consumption lounges is something that's top of mind for us, something that we've heard and discussed a lot about it. So that's where this came from. But as far as guidance, if somebody has to sit there the whole time, I mean, that's certainly reasonable and something that I think we can do through some policy statements to the industry.
Yeah, so and just to go back to sort of the comment about in gaming, you know, in gaming world, there are surveillance standards that are issued, and they're technical standards. They're not engulfed into the regulation. So we could certainly issue some surveillance standards that further define what's in the overall regulation. But I mean, for purposes of consumer protection plus tax revenue, it's important to have a record. And that's what the surveillance does provide. But it's the people on the ground who have to observe, you know, what's going on. That's where the protection comes in. It's not from as the chairman said, it's not from someone sitting there just looking at a camera all day. And that's not what surveillance typically does. You know, they're focused on high risk areas. And so that's point of entry, point of exit, you know, not going to watch every patron what they're doing all day in the lounge. So yeah, I think as Tyler suggested, maybe we can come up with some surveillance standards that further hone, you know. But again, I don't know, we need to amend I guess we would need to amend the regulation to take out the, you know, the timing of it. Again, I just looked at it again, and I don't know if we need to amend the regulation or just go with a further guidance statement on surveillance and sort of what that means, because it's going to change. Because I don't know, you know, if it's going to look like a bar, like a little bar, or it's going to be a giant gymnasium. I don't know what it's going to look like right now. And as we've always said, this is going to be a work in progress for some time to come.
Any questions?
Chairman, I think I have a way we could interlineate it. If we don't need to, then pull it and notice it. If you just took out the word continually, and then at the end put as prescribed by the Cannabis Compliance Board, then it would allow us to issue guidance on how frequently it would need to be monitored or the standards for monitoring it. So I would be in support of that if it doesn't mean pulling it. Otherwise, I think we could go with what's there, with it being said on the record that guidance would be issued.
Deputy Ballot, this is Tyler Klimas for the record. If you were able to listen to Member Durrett's suggestion, would that be a possibility for the board to consider? I don't believe it changes the intent substantially with this. If you need us to repeat it, we can. Deputy Balducci, what do you think about this issue?
How did I know that was going to happen? For the record, Senior Deputy Attorney General Ashley Balducci. I think you could strike continually and adopt it, but then if you wanted to add as prescribed by the board or as provided by the board, we would probably just need to renotice if you're adding to it.
And that makes sense. We're already going to renotice
The other one, so why not adopt it? You can adopt it as is, but you're striking continually, and then we can do an amendment in a new notice.
Specifically, the changes to this specific NCR doesn't even kick in until January 1, 2023. So it's easy to do that.
Precisely.
Nice to have something easy. Any other concerns or unreadiness or just thoughts for the floor? Before we look for a motion. All righty then. Would a board member like to make an attempt at motion?
I can do that, but I need to go back to which are, would it be all of basically C, D, E, F, and G? Wait,
H, I, J, K, and L
H, I, J, K, and L? Okay,
with the modification, I guess. with-
okay,
you would suggest.
okay. I move to approve the regulations proposed under agenda items H, I, J, K, and L with the modification that the word continually will be deleted from section, need a moment. 6.085, section 3, paragraph 8. The word continually be removed, and after the word business, the addition would be comma as prescribed by the CCB.
And just for clarification, record, that was C through L.
And Chair and Member Director, further the record, I think we can't add that piece yet, but we can take out continually. I believe that's what it was, but we can add, and this actually isn't effective till January of 23, so we have some time to make that addition anyway. I believe that's correct, right?
That is
Yep.
correct.
Okay, I'll start over. I move to approve the regulations under agenda items C through L under agenda item 9 with the removal of the word continually under section 6.085.
I would second the motion.
We have a motion, we have a second, we have any other discussion? Hearing none. All in favor of the motion has been seconded, say
Aye.
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 Motion carries unanimously. That take us to briefing from Chair and Executive Director for discussion only. Item number 11. Only comments from the chair is we are being asked again to put our advisory board to work, looking at fines, fees, and some of the costs. I guess kind of comports with what I've been asking our director to kind of orchestrate as we start looking toward our next legislative session. It's information we need to have to answer questions as best we can that the legislature might have at the next session. So it makes sense to do that. And with today being a long day, that concludes my remarks.
All right, I'll make mine brief, Chair. Thanks. I just want to take the opportunity to recognize the work that went into these consumption lounge regulations. This was a long 11-month process, but I believe that we have put ourselves collectively as the regulatory body, the industry, and the state in a position to launch this program, to do it in a way that adheres to our mission, protects the state, protects the public health and safety of the state, and provides for a new opportunity to achieve additional revenue for the state and add to this industry. But I again would like to thank my staff, the staff of the CCB, for a lot of hours put into this. I'd like to thank the counsel, our counsel from the Attorney General's office for all the work that they put into this. the Cannabis Advisory Commission, the subcommittees of the Cannabis Advisory Committees, and the chairs of those subcommittees, members of the public, and then obviously members of the industry as well for all the work and the review and the comments. I think this was a very open and transparent process, and I certainly appreciate the work that went into it. So with that, Chair, I'll conclude my remarks.
Just one comment. For those who made public comment today, on behalf of the board, we appreciate that comment. We are kind of the conduit between the public and the legislature to make this happen. We can't make it happen without your comments. And from just another perspective, the process needs to be real and needs to be inclusive. Too often, only the well-heeled are invited to the party. Everybody needs to be invited to the party. With that, our next meeting is set for July 26th of 2022. And I don't think we have any items for further agenda, even though we have items that we will be still considering as we play with what we did today.
Chairman, can I ask, I thought this would be appropriate under items for future agendas to now that we've gotten over some of the bulkier obstacles that are very time consuming, turn attention back to or put in the pipeline the study on the legal market that was placed under AB 533. So maybe the advisory committee that will be discussing fines and fees could also work on that, or maybe a separate one would be more appropriate. It's outlined in NRS that there's several provisions that they would pay attention to, but I'd like to ask to put that on either on a future agenda or just assign it to the advisory commission now so we could get presentations on that matter on a future agenda.
Well, we'll ask as we talk about the advisory committee, because one of the other things that's been brought up by one of our advocates is looking at pilot programs for the cannabis industry. And the advisory board should begin to turn its attention to looking at that subject matter as determined by the legislature. So without further ado, unless a board member has something else, it's proper to say we are in adjournment. Thank you.
Thank you.
Yes, I'm sorry. Oops. Public all day. But anyway, with that, so we're not in violation for any additional public comment.
My thanks apologies to the board and to Honorable Douglas.
No, you make sure you're doing the right things.
I wanted to be in the right timing, so I held my last comments. I wanted to just go on record on item number 7. G5 cultivation was up here, and prior to that, board members had given exemplary comments towards the other licensees. So I wanted to go on record also giving exemplary compliments regarding G5 and their community activism, activists, advocacy, and philanthropists. They have always been available to the community, especially the social equity community. So I wanted to go on record saying that we appreciate G5 cultivation always being available to the community. And then lastly, I wanted to go on record asking that when we do a study, if a study is being introduced, it relates to expanding licensing for the previous licensing, cultivation, production, science, and dispensary, that micro businesses are also being included in that study, that we don't neglect the opportunity to have availability for those businesses that we hope will be coming in soon. Thank you.
Other public comments? Any public comment in Carson City?
No comment.
Repeat myself. Chair Douglas, we are now adjourned officially. Thank you.